Our first case today is States Newsroom, Inc. versus City of Jersey City. May we have appearances of counsel?
Jeremy Jacobson for the appellant, City of Jersey City, Sean Yellow here in his position.
Michael Tucci, so it's coming some growth. We have the Municipal Clerks Association.
Good morning, CJ Griffin of Passion Line Walter Eden for the respondent States Newsroom, publishing the New Jersey Law.
Morning, Your Honors. Deputy Public Defender Michael Novak, at the Office of the Public Defender.
Thank you. Mr. Jacobson.
Good morning, Your Honors. I'd like to first ask to reserve 3 minutes for rebuttal, please.
That's fine. Thank you.
May it please the court. This case involves a public records request for an IA report that contains expunged information. Because the expungement statute prohibits law enforcement agencies from not just disclosing expunged records, but also from revealing the existence of expunged information, the appellates respectfully ask this court to, in part, reverse the appellate division and reinstate parts of the trial court's decision upholding denial of the request and sealing the record. To the extent that the court allows any part to stand, the appellants also ask for clear guidance of the legal mechanism to which the law enforcement agency can answer requests and respond to access lawsuits without exposing its employees to criminal penalties for revealing the existence of expunged records under the expungement statute. Expungement is one of the few areas in New Jersey law where the legislature chose to elevate confidentiality over transparency in the context of public records. The expungement statute does so by imposing a set of obligations on law enforcement agencies once they learn about an expungement. Now, these obligations are housed at NJSA 2C 5215A. The first two sentences of that statute actually involve the internal process. Basically, what they require is that the law enforcement agency pull any criminal records and sequester them with a designated person. That designated person must ensure that the records cannot be released, referred to, or used for any purpose. But this case is not about internal use of government records that have been expunged. It's about an external public disclosure of expunged information. The third sentence of section 15A of the statute is key here. It's the only provision in the expungement statute that deals directly with the question of requests made to the agency. It doesn't deal with the designated person, but rather it covers the entirety of all employees in the agency. And it's very broad in scope. It applies confidentiality obligations not only to the expunged records enumerated, but to any information about the person's arrest, convictions, or any related legal proceedings. It mandates a specific response of no record information. The agency is not even permitted to verify the existence of an arrest or any type of expunged information, let alone give out records. It must respond instead with a legal fiction. And if the law enforcement agencies violates this, it exposes its employees to criminal penalties for knowingly revealing to another, that's the statute's wording, under section 2C 5213. Again, very broad language. So here, the Jersey City Police Department received state arrest records, investigation reports, and charging docs directly from the state police. This was in terms of a situation where a police lieutenant had been arrested at his home, and the Jersey City Police Department needed the records in order to conduct an internal affairs investigation. Without question, as soon as we learned of the expungement order, there becomes a duty to sequester those records and to ensure non-use. And without questions, those records must not be referenced, used, or disclosed except as permitted by law. And the respondent and the Office of the Public Defender are arguing that the restrictions go no further. They'd like to institute a rigid categories test where labeling the record civil or labeling them administrative is dispositive, and therefore subject all the information in the records to the common law right of access. But importantly, that's not what the expungement statute's plain language says. The expungement statute covers information, not just records. And here we have information copied verbatim directly from records that were that have been pulled and sequestered. We also have a narrative in the report which will doubtlessly reference the arrest, conviction, and underlying proceedings. And the IA report itself and the IA investigation itself directly resulted in the arrest, or directly resulted from the arrest and from the conviction. Thus, it is a proceeding related to the arrest. Because the IA report is replete with information that has been expunged, the city is very concerned that we'd be exposing, by giving out the IA report, we would be exposing our employees to criminal penalties, because by doing so, they're revealing the existence of an arrest that has been expunged. And as briefed, the expungement statute has no exceptions that allow for disclosure to media companies or anything even close under the common law right of access. The exceptions that do exist are limited generally to government entities using and referring to records for internal purposes or for sharing among government entities. Additionally, 15A's non-verification obligation and also the criminal penalties present a problem when we need to argue in court. When we get if a public agency that's covered by the expungement statute is to get a complaint, they have to answer the complaint. And in answering the complaint and being able to respond, it's necessary at points to reference the arrest, conviction, or legal proceedings underlying the matter. Therefore, they would risk, again, exposing themselves to criminal penalties under Section 30 of the expungement statute. And for this reason, the city believes, and the appellants believe, that the trial court got it right here by denying the request, upholding the denial of the request, and by sealing the record in order to protect employees of the city who are covered by the expungement statute.
The Attorney General tells us that direct references in the IA records to expunged convictions can and should be redacted, but the rest of the IA report should be unredacted. Why is that not sufficient?
So I would agree with that. They definitely should be redacted. The reason it's not sufficient is twofold. I can say the first part of this is because we can look to directly to the language of the statute 15A, again, the third sentence. And the third sentence is very broad. So the city's concern is that it covers related proceedings. And our argument with that would be because the arrest and because the adjudication directly led to and triggered our IA investigation, that our IA investigation is a related proceeding. And therefore we shouldn't be, we'd be concerned that by giving information about that proceeding, we would again be exposing our employees to criminal penalties. The second part of it has more to do with the mechanics of litigation when you're dealing with the common law right of access or any public records request. So in order to respond to a public records request, say we decide that we're going to redact. Well, when you respond to a public records request, the city is obligated, under existing law, to provide a reason for the redactions. The problem we run into, practically speaking, is that the expungement statute forbids our employees from revealing the existence of the underlying matter. There's not really a practicable way for us to redact something and then explain that it was redacted because of the expungement statute without actually referring to the fact that it's an arrest, a conviction, or an underlying proceeding.
Do you view 15A as encompassing not just expunged records, but anything having to do with that individual?
I think it encompasses not anything having to do with that individual, but anything having to do with that individual that relates to the expunged matter, that relates to the expunged arrest, that relates to the expunged conviction. So 15A, it doesn't just cover records, I think is the main point. It covers information about that because the entire purpose is to give a reformed offender a second chance. And the way this is accomplished is not by deleting information from society writ large, but it is accomplished by making it so the criminal justice system is not the vehicle by which the expunged information can be accessed or verified. And here you have a situation where the media is looking to access and verify that information directly from those who are forbidden to give it out.
Can we look at the definition of expungement and expunged records in 52-1? And can you let me know where you see this definition encompassing the entirety of an IA report. So I see expungement defined as the extraction, sealing, impounding, or isolation of all records on file within any law enforcement or criminal justice agency concerning a person's detection, apprehension, arrest, detention, trial, or disposition of an offense within the criminal justice system. And then 1B, expunged records shall include complaints, warrants, arrest commitments, processing records, fingerprints, photographs, index cards, rap sheets, and judicial docket records.
Right. So I'm sorry.
Go ahead.
So it defines the expunged records. It's as that way. Expungement, that's just giving you I would say that that's just giving you an idea of what the process entails. So it gives you an idea of the purpose of expungement. That would be the purpose of 15A. It's a starting off point that kicks off that identifies when expungement or what falls within the definition of an expungement. As far as the records, it's a non-exhaustive list. It only includes those records. But again, I think we go back to 15A because once a material is subject to expungement, or once a court has entered an expungement order, what it really covers is not just the records, the specific records like the arrest reports, the investigation reports, et cetera, but it actually does talk about the fact of the arrest, the fact of the conviction, and the fact of the related proceeding. So my answer to that would be that's a general definition to highlight what expungement generally entails, and it defines records in section 1B, but it doesn't discuss the information in the records, which is much more broadly prohibitive as you look into the details of the rest of the statute.
What's the mechanism in place in a unit like the Internal Affairs Department where they don't receive a letter concerning the expungement, correct?
Mm-hmm.
So they don't receive any information that this record has been expunged. So when they look through their records and they're being asked to release documents, how do they know that the expungement has taken place or that it applies to that particular file?
So, well, typically, when an expungement's put through, it's sent to the agency. That is the agency that arrested or convicted the person.
In this case is not Jersey City, correct?
The original case that triggered this was actually in Sussex County. The agency that arrested our police lieutenant at a personal party for a personal matter was the state police. So I believe the mechanism that works is once the state police arrest a police officer, I believe it's pretty much automatic for them to notify the agency that employs the officer that the arrest has been made, and that's what triggers the IA investigation. As far as the expungement is concerned, and I don't know that all of the particulars, but from the impression that I get from it, as far as the expungement is concerned, when the expungement is entered, there's a list of agencies to which the expungement must be sent. In this particular order, which I don't have in front of me, but going from the best I can remember, there were certain clauses in the order that made it so that those agencies had to do particular things with sequestering the record, but then the language of the order got broader and made it so that they were required to notify any other agencies that would have already gotten those expunged records, which would have included Jersey City because the records were sent to us.
But they were not one of the directed locations that would have normally been included in the expungement order regarding place of arrest, county of commitment, county of that handled the matter, and state police. Like Jersey City wouldn't have been on that list.
Jersey City was not on the list in the original order. That's correct, Your Honor.
I mean, correct me if I'm wrong, but it may not have occurred to any of those other departments on that list, including the departments in Sussex County, to reach out to the IA department of Jersey City.
I believe it's possible that would be the case, yes. And
so at what point do they determine that, because I'm thinking practically speaking, how does every internal affairs department of every department in the state recognize that there's an expungement in place that they now need to be aware of in order to prevent the issue that you're concerned about, which is your employees' ability to be free from possible prosecution for releasing the information? Because that becomes a challenge for them, doesn't it?
It does, and unfortunately, this is a part of the expungement statute where I can't entirely remember the particulars. I know that there is a computerized mechanism set in place to keep track of expungement statewide. I can tell you that what happened in this particular case is that the Police Superior Officers Association provided us with a copy of the expungement order.
Because of the pending requests and the fact that litigation was.
Right, that was in the middle of litigation, correct, Your Honor.
So typically, this might not be the way that this would develop, which is, we need to keep that in mind as far as how to suggest that this would happen in the future, correct?
Correct. I think that's absolutely true. I can say this. So as a law enforcement agency that's covered by the statute, where our employers are covered by the statute, it is important to note that Section 30 only applies as an offense when somebody knowingly discloses the information, knowing that there's an expungement order out there. So say, for example, we had settled the case prior to the point that someone got an expungement order to us when we didn't know, there wouldn't be the concern at that point of the city in terms of its public employees, because the city would not be guilty of knowingly disclosing the information. I do think it's a very good point, Your Honor, and very wise to say that it would be helpful if the state had a mechanism in place, and maybe they do, and I'm just not remembering it or not aware of it, to specifically pinpoint all of the agencies that had been involved before. That I think would be something that, if it doesn't exist, the legislature could certainly step in and remedy that. But obviously, that's not what's before the court today. But as a practical matter, I think that it's a valid question.
Counsel, you've been focusing your argument significantly on the language in 52-15A and specifically on the term related proceedings. So I just want to have an understanding of how far your argument is extending with regard to what encompasses a related proceeding. It sounds as though you're arguing that any sort of proceeding that arises from the incident that was the subject of the expunged criminal records would be considered a related proceeding. Whereas in your colloquy and the questions that Justice Weiner-Apter asked, we discussed a little bit the definition of expungement in 52-1. I think a logical reading is reading those definitions in conjunction with 52-15. And it seems like a logical reading would be that those related proceedings would be proceedings related to the criminal matter, the criminal prosecution, as opposed to any proceeding that could have arose from the facts of the incident, which could involve a civil proceeding, a civil matter. So how far does your argument go with regard to what encompasses related proceedings?
Well, Your Honor, I think the call of your question focuses on one phrase in 1A, which is within the criminal justice system. And I think that's a valid question. Here you have a situation where the city is a law enforcement agency, and we're one of the named agencies in the statute, law enforcement agencies, courts. I'm trying to remember what the other two are now. But there's two other named agencies in the statute. Prosecutors' offices would be among them. So we do exist within the criminal justice system. So my argument would be that it might not be for every single type of proceeding, but an IA proceeding is conducted by law enforcement or is conducted by law enforcement officers.
Right, but not every IA proceeding arises from a criminal matter, correct?
Correct, Your Honor, that is true.
Okay, so it's not necessarily the case that an IA proceeding, by virtue of the existence of an IA proceeding, has to do with a criminal prosecution or a criminal investigation for.
That is correct, but I would also argue that an IA proceeding could arise from a civil matter, but you could have facts that get into an IA file that involve those who are outside parties who are not necessarily law enforcement officers themselves. I think the way I prefer to look at it is information held by a criminal a law enforcement agency, and we're part of the criminal justice system. So if
But the
information,
within the criminal justice system is actually not referring to the agency. It's referring to the apprehension, arrest, detention, trial, or disposition of an offense. So it seems like you're changing the way the statute works to say that all records on file within the criminal justice system are expunged. But the statute specifically says that it's talking about all records on file within any law enforcement or criminal justice agency concerning a person's detection, apprehension, arrest, detention, trial, or disposition of an offense within the criminal justice system. And I think your adversary's point is that the IA records in and of themselves, perhaps with any information about an apprehension, arrest, detention, trial, or disposition of an offense within the criminal justice system redacted, are otherwise not records about the apprehension, arrest, detention, trial, or disposition of an offense within the criminal justice system. So how do you respond to that?
so I think the city's position here is first and foremost that we need to make sure that we are adhering to the plain language of the statute, because there's a lot at risk here if we get it wrong. If we give out an IA report and it's determined that within the related offense includes what happened in our IA report, we're exposing our employees to criminal penalties here.
So then can we look at section 30, the specific language? It says any person who reveals to another the existence of an arrest, conviction, or related legal proceeding with knowledge that the records and information pertaining thereto have been expunged or sealed is subject to this $200 fine and this disorderly person's offense. So what is your argument there precisely? Is it that every single IA proceeding is always a related legal proceeding to an arrest and conviction?
I wouldn't say every single IA proceeding, because as your honors have brought up, not every single IA proceeding has an offense attached to
But
it.
every single IA proceeding that there was a criminal prosecution that was expunged.
I think that would summarize our position probably correctly, your honor. Yes.
So if there's an IA proceeding and there happens to not be a criminal prosecution, then everything is fine.
Or an arrest, your honor. Yeah, because the arrest is also covered as part of the information that is expunged. If there's an arrest that was expunged, the city also cannot reveal the existence of the arrest that was expunged.
I understand not revealing the existence of the arrest that it was expunged. I'm having trouble understanding why that means you don't reveal the existence of the IA investigation, especially if the IA investigation preceded the arrest, is totally different from a criminal investigation. You know, it's established that the burdens of proof, very different, consequences in IA versus a criminal proceeding, very different. So I'm just having trouble understanding why, if a criminal proceeding, if the person happens to be charged with a crime, the entire existence of the IA investigation all of a sudden becomes expunged.
I guess I would go back to the same type of practical problem that we'd run into, additional to the concern about the related proceeding definition. The city, here what we have is we have a common law right of access request. So the city has to respond somehow. And the redaction solution really doesn't work from a mechanical perspective, because as soon as we redact the information, we have to make a justification for our redaction. And the justification for our redaction, if we say we're redacting this because it involves an arrest that was subject to expungement, we are revealing the existence of the arrest by way of justifying a redaction. Now, say we don't.
What if a redaction explanation could be something generic, like in accordance with law?
Your Honor, that's exactly where I was going. And the problem is that then if we give something generic to a requester, the requester has a right to initiate a lawsuit against the city. So the lawsuit against the city, they could say, well, the city didn't justify the redaction. We don't believe the redaction is justified, or we don't believe the redaction is appropriate in scope. and they can bring a complaint against us. Now the city's put in a position where we have to go onto a civil docket, which is of course open to the public, and a city employee, an attorney for the city, or someone, agent that's on behalf of the city, would have to go and try to defend a case with a hand tied behind their back because they can't reveal the existence of an arrest, they can't reveal existence of a conviction, and these are integral facts in the
But
case.
how is that different? I'm sorry. Let's say you just don't reveal the report at all because you say that it has been, I assume you're going to say it has been expunged. So how is that any different from saying the redactions are being redacted because it has been expunged?
Actually, Your Honor, we wouldn't. What we would say is that there's no record information because that's what 15A of the statute requires that we say.
So someone requests an IA report and you just respond, there is no record information, but you could not do that for a redaction. I'm not understanding why the challenge is any different if you do it for the entire report versus for the redaction. Presumably, if you respond to a request for an IA report, there is no record information, someone could sue you and say that is violating the law.
Well,
and then you would be in the exact same position, but just regarding the IA report as a whole instead of specific information within it.
So I think the mechanics here are very important. So if we put redaction, if we say we black out the part that we redact and send that back to a requester, and we say there's no record information, but it's blacked out, that's going to pretty much initiate a lawsuit, or it's going to, potentially reveal the fact that it's expunged. If we just don't give out the record and then they sue saying that we denied it incorrectly, then that you get to the question of sealing, because in order to respond, the city needs to be able to say, we have a valid reason for not providing this record. It's because the expungement statute exists and there was an arrest and it was expunged. But
when let's leave expungement aside, how does the city handle that when it gets a records request and there's some other basis to either redact part of the record or to withhold it? How is that handled? Obviously court ultimately may very well look at it in camera, right?
Right. So typically that would be the case, but before you even get to an in-camera review, we would still have to answer the complaint. So in other situations where you're dealing with a common law right of access request, you don't have a statutory prohibition on mentioning something. So we can say, we're denying this because we believe that there's a reasonable expectation of privacy.
Or a reasonable expectation? What if let's say a HIPAA information is asked for in a request. Would you cite HIPAA?
So what we would do, right, but HIPAA would work differently because HIPAA, you can't give out particularized health information. So we would cite to the statute, but citing to the statute doesn't identify this particularized health information.
It tells you that there's health information and that the basis for the redaction or the withholding of the document is a medical privacy issue.
Sure, but the revealing the existence of the fact that there's private medical information doesn't, to my knowledge, and I'm not an expert on HIPAA, but doesn't run directly afoul of the statute the same way it would if we reveal existence of an arrest or conviction in the context of expungement. The expungement statute is very clear and detailed on the fact that we can't even reveal the existence of it. So it puts us into a kind of a bind and a catch-22. Normally, it's not a problem because whatever justification we're using is not actually prohibited by law, but in the case of expungement, it is. So
I'm sorry, go ahead. Go ahead. You're suggesting that in the case of expungement, because of the statutory requirement of a non-informative response, there needs to be some guidance with respect to what is an appropriate response if there is a redaction or there is withholding of a document.
I mean, at minimum, Your Honor, obviously the city is looking to have the trial court's ruling upheld. But if part of it, any part of it wasn't upheld, then we would absolutely need guidance and we need to be protected. So we're not putting our employees in a situation where by virtue of responding to the request, they're putting themselves in jeopardy of getting a criminal record that they themselves might have to go get expunged. It's a situation, where I think guidance is definitely necessary under.
Are you saying the normal process that I'm sure in a city, this is a municipality the size of Jersey City is fully established of citing a reason, perhaps a statutory basis for a response won't work here because of the legislature's mandate that the the expungement not itself be revealed.
Absolutely, Your Honor. That's exactly.
So
what
I
we're
guess
saying.
How is that different, again, for the whole IA report versus, I'm not sure why it's effective when someone requests an IA report to say there's no record information and then guarantee you're not going to be sued, or if you're sued, somehow be able to respond to it differently based on sealing, than if you have the IA report, which you release with any expunged information redacted. You include the exact same response that you would have where you say there's no related proceeding, then they sue you, then you're in the exact same position that you would have been with regard to sealing, as far as I can tell. I'm just not understanding why it is only workable for you to not release the entire report,
I guess,
even when it has nothing to do with an arrest conviction.
I mean, that's a fair question, Your Honor. I guess as a practical matter, if we respond that there's no record information to any request, it's fairly unlikely that a requester is going to challenge that, because they'd have to somehow prove that there's record information. The issue, we would run into an issue where if someone did sue us, we would have to ask the court to submit under seal. The reason that we said there's no record information is because this is actually expunged and we can't tell anybody about it pursuant to the statute.
Correct. And you would do that regardless of whether it was a few lines that were blacked out or the whole report, correct? The sealing is the same.
I don't know of, I'm trying to think of all the various scenarios. I can't think of a scenario off the top of my head that would be different. I can just say that that the redaction would create more obvious problems for the city in the response than simply replying that there's no record information as the statute requires.
We'll be asking the Attorney General about this as well.
Counsel, I would like to go back to the language of the statute. Again, we've been focusing a lot on related proceedings in 52-15. So in looking at 52-30, Justice Wiener, after read a portion of that statute, that's the statute that details the penalties for the revealing of expunged information, and states any person who reveals to another the existence of an arrest, conviction, or a related legal proceeding can be fined a certain amount of money. So in 15-30, it specifically says related legal proceedings. In 52-15, it says related proceedings. Is there a difference, and why is there a difference or not? I think I discussed earlier that it seems a logical reading of related proceedings in 52-15, reading the statute as a whole. A logical reading is that it's regarding related proceedings to the criminal prosecution, to the arrest, to the conviction. And then we have in actually the penalty provision, it's pretty specific that it's related legal proceedings. So what do you make of that?
Well, the legislature wanted to, it could have specified related legal proceedings in both areas. So it may be that the legislature only sought to criminalize the disclosure of when it's very clearly related to the criminal matter. And it chose to be a little bit more broad in the third sentence of section 15A.
But your concern, as you've noted already during this argument, is that you need to protect your, the city, and in receiving these requests, making sure that you're adhering to the plain language of the statute. Seems like the plain language here in section 52-30, the penalty provision is pretty clear that the related proceedings for which someone would be subject to the penalty if they reveal such information that has been expunged is related legal proceedings. An IA investigation is not a related legal proceeding. No, I think you would agree.
I think that's a fair reading, Your Honor. I don't think it's 100% clear that that's exactly the case, but I could certainly see how someone would read it that way. I will still note that they are different, and I think they could be read differently. The related legal proceedings could be read because to include something that resulted, a legal proceeding that resulted directly from the arrest or conviction, like an IA proceeding, I guess the effect of that would be that it might not subject us to criminal penalties in that regard. But we could also look at an IA proceeding as a legal proceeding.
Well, it's administrative.
Right.
Administrative, maybe a subset of a legal proceeding.
The IAPP, the AG's IAPP specifically states that internal investigations are not criminal investigations and are distinct from criminal investigations, and that instead of investigating crimes, they investigate violations of agency rule, regulation, or standard operating procedure, correct?
That sounds right, Your Honor, yes.
And so an IA investigation, by definition, doesn't concern the detection, apprehension, arrest, detention, trial, or disposition of an offense within the criminal justice system. Instead, it concerns violations of agency rules or of conduct or regulation of conduct.
So, yes, it does concern agency rules. What I would say is, though, again, going back to the point, it will contain information about the arrest, detention, apprehension, and so forth in the criminal justice system within its confines. So it's not the same thing, but it contains the information. I think what we're tasked with is making sure that we're not the vehicle by which that information gets made public.
So I'm sorry, go ahead.
If we were to disagree with you that the entire IA report would have to be withheld, I thought that I saw in your briefing that you were also making an argument that any information that appeared in a criminal justice investigatory record that was copied into the IA report, even if it doesn't mention arrest, conviction, or related legal proceeding, and is instead a statement of facts or something like that, would need to be withheld because it also is contained in a record that was expunged. Can you explain that, if I'm correct, that was your argument?
Yes, Your Honor. So one of the things that was contained in this particular IA report, there was a large verbatim.
The IA report, just so we know, not in the record, right?
Correct. So,
never actually reviewed by the trial court.
Correct.
Or the appellate division.
Correct. The appellate division remanded it back down. Then we petitioned for certification. The trial court just declined to review the record in camera, and that was when the appeal took place. So the IA report, based on certification below, the facts do state that the IA report contains a significant portion of information that was copied verbatim or near verbatim from, I don't remember if it was an investigation report or an arrest report, but from one of the police reports where it just essentially was transposed. So, Your Honor, I would argue that public policy underlying the expungement statute, because we're not to be revealing information about an arrest or conviction, and because the records that are defined in Section 1B are very clearly not to be given out, it would kind of eviscerate the entire purpose if the fact that we copied verbatim from one of those particular records into our IA report, if we could then make most of or part of or some portion of the record then public by virtue of transposing it, when if it had just stayed in the investigation report itself, it would have been completely off limits.
Well, let's test that theory a little bit. If you flip the circumstance and what you had is somebody seeking to access the IA records because it affected the citizen subject of the IA record, right? Whoever was the citizen involved and not the police officer, but they had whatever the involvement was resulting in a crime that was later expunged. There would probably be no way for that police department. Let's say it happened in a similar circumstance where it wasn't in the town where the person was arrested. There wouldn't be any mechanism involved for the police department to get the expungement record of the defendant in that circumstance, right? Because the only reason that Jersey City received the expungement record was for reasons you stated that had to do with his employment there. That wouldn't happen if it was a defendant in a case that was expunged and happened to be the subject of the IA record. So in that case, public policy aside, it would be released because the police department would have no idea that expungement existed. So really, this is just public policy as to police officers that are the subject of IA records. And isn't that not what the expungement statute set out to do? That doesn't seem like a carve out that the legislature intended.
So I'm just trying to make sure I'm following the fact pattern here. So there's something in our IA report that references an individual who later got their conviction expunged. I believe the mechanism for that person to protect themselves would be if they know that they're a subject of our IA report, to bring the expungement or to inform the Jersey City Police Department of the expungement, and then we would be aware of it, and then we would also, for the same reason, not be able to disclose it.
But none of the criteria for filing for an expungement or securing an expungement would have that as a requirement. So no citizen would know that that's their right or ability to do that, because all the requirements are related to the place where they were arrested, anywhere they may have been detained, any county that may have touched their case. So they may not have any idea that that's a requirement. So it would really just be serendipity if they happen to decide that maybe that internal affairs record of some other town that, reviewed this case should receive a copy of the expungement.
But I think that's probably somewhat true, Your Honor, but I would also argue that serendipity was the same here when it did involve a police officer.
But a police officer who would know, because his potential career was on the line, that he should provide that expungement record to his employer. And so go ahead. I don't know if you.
Well, I would think under the hypothetical, you're suggesting the person who was the subject of, let's say they were arrested by one of our police officers, and they were, if the IA report came about because of a complaint, for example, then I think they'd be aware that the Jersey City Police Department might have a file on them, and they would also be able to, because they didn't want their record, the record of their conviction in our files either, be able to present us with the expungement order. So
that's not the way the expungement statute's designed. It's not about a person saying any police department in the state where I think they may have some information on me gets a copy of my expungement. It's very detailed in terms of connected to the case for which you are expunging a matter. And that makes this case particularly unique in the sense that Jersey City happened to get the expungement record, but for that fact, the IA department may not have known that there was any problem with releasing this IA record.
I mean, so I'm thinking to something else that did happen, that did occur. And again, I'm not entirely sure of exact mechanism by which this happens. But in 2019, I believe the expungement statute was amended, because originally, and some of the cases that were cited in here cite back to what it used to be, a GD, for example. Originally, who was noticed turned on, or the statute turned on, notice, who was put on notice of the expungement. But when they changed the systems, they changed the language to cover all of the agencies which at the time of the entry of expungement possessed the records. And going from vague memory of what the expungement order entered in this case had in its provisions, towards the end of the provisions in the expungement statute, maybe middle towards the end, there's one of the provisions that required that the agencies that were originally noticed also notify any other agencies to which they'd provided the records that were expunged, so that they would be aware that they were expunged and they needed to be, not given out.
So agencies that are not enumerated in the statute as agencies that have to be notified do, I would assume, sometimes get notice of an expungement order.
That would be, by my read of the order in this case, that seems to be how it would have played out. Yes, Your Honor.
In your case, it was the police union that provided you with your.
In our case, yeah, we weren't aware of it until the police union gave it to us. That's correct. The police superior officers union.
So how, in the defendant case, or if there was an encounter with a police officer and an arrestee that led to an IA investigation, Justice Noriega is mentioning, what would be the typical scenario for that to even find its way to Jersey City, if it would?
Just trying to think how this would work. So this is someone who was arrested by Jersey City. Well, if they're arrested by Jersey City, then we would be notified as, of course, because we would be one of the named agencies because we're the arresting agency.
So that would be easy.
Yeah, that would be easy.
There might be some strange
There'd
scenarios.
have to be a very strange scenario where we conducted an IA investigation on someone who was arrested in another jurisdiction, and where we wouldn't be notified of.
So you're.
So let's say someone is alleging that in the course of an arrest by Jersey City, there was serious misconduct by a police officer. And let's say the IA report is sustained. The fact that the person has their conviction expunged means that Jersey City does not have to disclose anything about the fact that that IA report was sustained and that there was discipline imposed, because the entire process now becomes expunged because the person who was arrested got their criminal record expunged. I'm just not understanding how that could possibly be the intention of the expungement statute.
So if I'm following what you're saying, so so you're saying that there's expunged information. There's information about someone who was arrested, and they were subject to a detention or something unlawful that our police department did, and there would be
and the IA report is sustained and there's discipline imposed, but now no one can get a copy of that IA report or any information about it, because the fact that the person who requested the investigation to be undertaken had their arrest that they claim was wrongful expunged. Why is that what the expungement statute is aiming to get at? Or how is that possibly how the IAPP and the expungement statute interact?
Well, the expungement statute just says that we're not first of all, if it was a third party, most of the time you're talking about a third party. I think you'd be talking about specifically when the person who was the beneficiary of the expungement wanted the IA report. Am I following that, or would it be a third party?
It'd be either way.
Okay.
Because I mean, the expungement order would, you said, go to Jersey City as of course anyway. So regardless of whether it's the person whose record was expunged or a news agency that is trying to do a report on sustained discipline where major suspension was, or some sort of major discipline was imposed, why would it matter?
Well, I think it would matter because the person who is the person who has the record expunged would be the one who would have the right to privacy and the right to the expungement. The expungement.
There's no exception in the expungement statute for.
There is no exception in the expungement statute that deals with that exact scenario. That is true, Your Honor. I don't think it's something that the legislature likely contemplated as a fact pattern.
That individual may have just as tough a time getting their own records once they're expunged as anyone else, as any third party.
Well, they would all. I mean, technically speaking, they would already have access to.
They might have had prior records, but let's say they were all destroyed. They have nothing, but they need a copy of the IA records because they want to pursue some civil action. So their request to the court would be denied, or request to you would be denied.
The request, I guess, here's the distinction. That person would still have the ability to get that information through discovery in any court case that they bring. The common law right of access is not really intended for criminal cases. I think I want to say it's a case called State versus Marshall, if I'm remembering the case. I have it written down somewhere here. But that actually speaks directly to that. So a person who needs this to pursue a criminal or civil case, a person who's actually aggrieved to the Jersey City Police Department, it's not like they wouldn't have a way to get the information. It simply wouldn't be the common law right of access. They would go get it through the discovery process.
I'm sorry, I'm confused. I thought you said that the reason that we're talking about this at all is because the expungement statute prohibits the release, regardless of how. So where in the expungement statute does it say it cannot be released pursuant to the common law right of access, but it can be released in discovery in civil litigation that the person files? Section
19 would be what they would use. And the expungement statute, that has to do with court cases. And that was Child Protective Services versus AP. And this court laid out a very specific way that someone could bring it into a case.
So that's on good cause shown and for compelling reasons. So it's not simply the request, even if it's in discovery. If the request is subject to an expungement, the requester still has to make a compelling showing to a judge before it would be released, correct?
That would be correct. But under the fact pattern that Your Honor gave, I would think that would probably be a compelling reason, and they'd be able to make that case to a court.
Counsel, you said before that, and you said in your briefing, that much of your IA report was taken verbatim from the documents that are expressly precluded by statute. But that feels that runs counter to the way, for instance, the Attorney General described how an IA process should work. On page 7 of their brief, they go through that and they say the two processes should be kept separate. They say IAs have their own independent investigative authority. They interview witnesses, they uncover information. Isn't there a distinction? Doesn't your argument change when either the IA report is taken verbatim from the documents that are listed in the statute, as opposed to as a result of a completely independent investigation that's not contingent upon or dependent upon or directly reference the documents that are referenced in the statute? Aren't they two very, very different factual scenarios? One that you're saying Jersey City did, one that the Attorney General lays out for how IA investigation should work.
So, Your Honor, I think that's a good question. I would say that, first of all, just to be clear, it's not that the entire IA report was taken verbatim from criminal records. It's that a significant portion of it was. So you
said a significant portion was?
Yeah, I mean, it was, I don't know the exact percentage by pages, but it was, maybe 30, 40, 50%, of the lead-in of the.
Just your briefing says much of it copied verbatim or near verbatim from expunged records.
Correct. And then, so the IA report has a significant amount that was copied verbatim or near verbatim, which established a lot of facts as to what happened in the incident. That came verbatim. A lot of that came verbatim. And then, additionally, there's other attempts at investigation, fact finding, and so forth independently. Some of that will doubtlessly reference and involve the arrest, the conviction, the proceedings, and so forth, and interwoven into the analyses and everything that's done.
But isn't it a very different question when the derivation of the information is independently gathered by an IA investigation, as opposed to is just copied verbatim or near verbatim from records?
Well, I mean, I would think that a typical IA investigation would do both. There would be some things that would reference to the criminal records when there's a criminal matter, and then there would be some situations where where the investigators would rely on independent fact finding. My thought would be it would depend on how, the extent to which they were able to interview witnesses versus to the extent to which they needed to rely on records. In some cases might be different than others. So I believe you're correct on that.
Let me ask you a complementary question to that. Earlier, you said can't reveal the underlying matter. That's what you said. I don't see matter or the issues being involved in the incident listed anywhere in the statute. The statute starts with detection. Certainly detection postdates matter and goes onward from there and discusses proceedings. But when you said that the underlying matter couldn't be revealed, where do you see that in the statute?
I guess that would be a summary. I don't believe that there's anything in the statute that specifically uses the term matter. But
that would be a summary. I'm sorry. What was the first thing you said?
I said essentially it would have been a word chosen to summarize, apprehension, detection, arrest, conviction,
but not the incident. Clearly, the incident falls outside of that scope and temporarily prior to that list, right?
The incident happens before the detection, correct, Your Honor.
And is not precluded by anything in that list. Information about the incident.
Not expressly, no, Your Honor. But to the extent that the IA matter is a related proceeding, it would be precluded from disclosure under the plain language of 15A.
The underlying incident is not a proceeding in any way. Information about that incident is not a proceeding. In fact, that incident, as I said, has to, by necessity, predate any of the list that's in the statute, right?
Correct, Your Honor, but the information about the incident would also be in the list of enumerated records, like the arrest report, any investigation reports, charging documents, and so forth. Those will reference.
As a general principle, if records are expunged, any record that an agency covered by the statute has about the underlying offense that led to the arrest, allegations, et cetera, would be included in the documents that are expunged. Am I
Yes,
right about
yes, Your
that?
Honor, and I think that comports with the whole purpose of the expungement statute, which is to make it, at least going through channels that are within the criminal justice system, such as the courts, such as law enforcement agencies, such as prosecutors' offices, and so forth. The idea is that the offense is supposed to have to be as if it never occurred. Now this doesn't, obviously, GD stands for the proposition that this doesn't mean as to members of society, people can't talk about it. But as a covered agency, we're not supposed to be talking about it. We're not supposed to be revealing the existence of it. So if we're revealing, the existence of the facts that are in an investigation report, I think that goes against the spirit of what the legislature was attempting to accomplish, which was closing criminal justice agencies and law enforcement agencies and courts off as a means by which the information can be obtained or verified.
What about the facts that aren't in the investigation report? We talked a little bit about the fact that an IA investigation operates separately from the criminal investigation, and there's witnesses that are interviewed. So during the course of an IA investigation, witnesses can be interviewed, and the facts of what occurred can generate portions of the IA report that have nothing to do with the investigative report, correct?
Well, that is correct, Your Honor, yes.
And that also might have nothing to do with the arrest. If there's an incident where someone's arrested and there's a victim, the victim might give an interview and have no idea that there was detention, arrest, trial, or the point when it gets to a trial, they would probably know. But there's a lot that the statute identifies that can be divulged during an IA investigation by a witness or by other sources that have nothing to do with the police report. I understand that here your representation is that a big portion of the the criminal investigation report, the police report, was, I guess, copied and pasted into the IA investigation. But I think that would result in additional concerns that if we agree with your position, that police departments could just isolate this information by using and transposing simply the information in police reports that are covered, by your argument, completely and in total by the expungement.
But I think that's the entire purpose of the expungement statute, Your Honor, is that those reports are supposed to be isolated.
Right. But again, there are facts and information arising from the incident that can be divulged, and I would assume are divulged and noted in IA reports that have nothing to do with the police reports, correct?
Yes, Your Honor, that fact pattern can happen.
So that information should be available and not subject to the expungement statute.
I would, again, Your Honor, I would argue that the
IA investigation is a related proceeding.
Correct.
But not a related legal proceeding.
Yes, that's correct, Your Honor.
Sorry, did I cut you off?
Anything you'd like to add at this point? We will have you back for rebuttal.
I would just like to add basically just a very quick point that I think there's a very distinctive difference between what the plaintiff is, or excuse me, what the respondent here is trying to say with respect to saying that the types of records are what matter, and here we're simply saying that the information is, the information in the records is what matters. And
Sorry, I missed that last point.
that it's not the type of record that the information is held in, but it's a type of information that's being held.
It's redacted information. The form of document is
The form of document is not, it's the fact that it's held by a law enforcement agency, and it's information that's subject to expungement is what part of our case is.
Thank you.
Thank you, Your Honors.
Mr. Perucci?
Justices, and may it please the court. On behalf of the Municipal Clerks Association of New Jersey, I thank you for the opportunity to join today's discussion as a friend of the court. I will limit my remarks to the first question presented, namely whether a requester can obtain an internal affairs report under the common law right of access if the subject of that report is also the subject of an expungement. We submit that the answer to that question should be no. And we encourage the court to view the issue from the perspective of the municipal clerk, the local public servant who is on the front line of responding to such requests. All across New Jersey, hundreds of records requests are submitted every day at the municipal level. And handling each of these requests are municipal clerks who also serve as records custodians. They do their level best to respond to each request promptly and correctly in compliance with the law. But not all requests are the same. As you know, members of the public can request records either through the Open Public Records Act or the common law right of access. When requests are made pursuant to OPRA, the statute gives clerks a roadmap. But as this court recognized in Gannett, common law requests are not as straightforward.
Before we go on to common law requests, in an Oprah situation, how would a municipal clerk know that a portion of the information that's being requested is subject to an expungement order?
Well, Your Honor, in the Oprah context, a clerk would review the statute to see if there are any exceptions to the rule. My understanding is that internal affairs reports are not available under Oprah, but they are available, generally speaking, under the common law.
But I'm not actually limiting my question. I just want to learn a little bit about the mechanics. My question to IA, which obviously is in the common law world, as in this case, but if there is an Oprah request, which I assume are the majority of requests that your organization's members face,
Yes.
and there is an expungement order that applies, is there a duty on the part of an agency within the municipality to notify the municipal clerk so the clerk is not inadvertently disclosing expunged information?
I'm not aware of if there's a duty on others to report and share that information with clerks. My understanding is that oftentimes the clerks will learn of this information in a passive way. And I believe that's somewhat how what happened in this case. And so that could happen in the common law context, that could happen in the Oprah context. If I can get back to the common law context for a second, as the court recognized in Gannett, the common law requests are not as straightforward as Oprah requests. They impose significant burdens on clerks and other custodians. They require a careful balancing of competing interests. And by my count, there's now about 11 factors, at least, that are set forth in the Loebman and the Rivera decisions that have to be considered. And as Justice Patterson, you noted in Gannett, this analysis can challenge even a seasoned judge. And that brings me to our main point. The decision below would pile on top of the burden already weighing heavily on clerks. Although the decision speaks of what the trial judge will need to do on remand, make no mistake about it, whenever a similar request for records is made in the future, clerks will be expected to undertake the same type of analysis that's required of the judge on remand. And still worse, the clerk would have to do so while facing the specter of criminal culpability. That is because the expungement statute criminalizes the knowing disclosure of expunged information. The decision below does nothing to protect clerks from that danger.
Well, what is the association's position with respect to redaction as a potential practical solution?
Yes, thank you, Justice, for asking that. I share the concern expressed by my colleague from Jersey City, who noted that oftentimes when a redaction is made, an explanation must be provided to the requester. And I'll give the court two sources of authority for that. First, the Government Records Council on its website has an entire page devoted to redacting government records. And on that page, it states that when redactions are made to a record, the custodian can either use the request form to explain essentially the reasons for the redaction, or use a separate document depending on the circumstances. And here's the key language. The bottom line is that the requester has a right to know the reason for the redaction, and the custodian has the responsibility to provide a reasonable explanation. That's the guidance from the Government Records Council. There's also authority from this court in the PATH case, where I believe if privileged information is withheld or redacted, the court has said that the party redacting that information must provide a privilege log to the other side. And so I think there are, as counsel noted, some practical concerns with the idea of saying, well, look, there is a strong interest in providing access to internal affairs reports. Why can't we just simply redact any information that's subject to an expungement order? That sounds reasonable on its face, but the problem is that the expungement statute says that you cannot disclose the existence of the expunged information. And so if let's say the internal affairs report were provided to a requester in this hypothetical, and it was simply redacted where the part references an expunged arrest or conviction, that redaction would, according to the guidance and the authority in PATH, seem to implicate a requirement to explain the basis for that redaction. Now, Justice Patterson, I noted you said, what if the reason was in accordance with law? I think the problem with that type of explanation is that the cat would be out of the bag. The requester would know that something's up here, that there is expunged information, and that in itself is problematic and would then encourage litigation for sure. In the end, I really think—
Wouldn't that be the case when they get a response? The entire IA report can't be provided because there's no record information.
Well, Justice, my view is that we don't take a position on whether the entire internal affairs report has to be withheld or that the response to that should be there is no record information. Our position is if it's clearly expunged information under the statute, then we cannot disclose the existence of that fact to a requester. And so that's the problem we run into when it comes to redaction. And
but you started your argument by suggesting that this could make the municipal worker's job more complicated.
yes.
But doesn't this broader reading of the statute actually do that instead? Because here, what you have is a situation that if the municipal clerk in Jersey City was asked to look for this internal affairs record, and there is nothing in that file that suggests that it should be deemed confidential, put into an expunged file, located separately, so it's released in the normal course pursuant to the statute. And nobody in that department would stop it because it's not under the expungement statute. I think it isn't what you're asking for them to sort of bend over backwards to figure out if there's an expungement somewhere and then go to the particular language. The internal affairs records were simply not included in the statute.
Right.
So aren't you putting an extra burden on them by going through all of these exercises?
I don't think so, Justice, and here's why. I think the issue here is that the clerk, that the municipality would learn that there are contents within the requested record that's subject to an expungement.
How?
Well, that information could arise and be transmitted in any number of ways.
And I understand that it could be, but
Right.
since there currently is no mechanism in existence that would allow that clerk to automatically know that there's an expungement in place when seeking simply internal affairs records, as opposed to the entire file, which may include arrest, conviction, sentencing records, because there's no mechanism in place to determine that, you're asking for the municipal clerk to have to go through extra hoops and extra steps to make that determination, or be lucky enough that somebody gets it to them. Because if we issue an opinion that says that they're obligated to know the difference, then now they will have to go through all the exercises to determine whether or not somebody has an expungement. For a municipal clerk, isn't that going to be a challenge, since there is no centralized place where they can look? If it doesn't impact their particular municipality, it's going to put a heavy burden on them.
I'm certainly not advocating to increase the burden on municipal clerks. I'm certainly not advocating for there to be a rule that obligates clerks to go out and affirmatively find out if there's information contained within a requested record that is the subject of an expungement order. All I'm saying is that when a clerk has knowledge that information contained in a requested record, and by the way, it doesn't matter from my view, whether it's an internal affairs report or an email between the mayor and the police chief. Once that clerk learns that there is content in that report or that document that's requested, they have to follow the statute. And the statute says the knowing disclosure of the existence of an expunged arrest or conviction or related proceeding is criminalized conduct.
But that seems like you just acknowledge that it's only the existence of the arrest or conviction. So then it seems like it would have to be redacted. Are you saying that the entire email between the police chief and I forget the hypothetical you just gave. I think it was the mayor and the police chief.
Yes.
There's a long email. It's about many things. It also mentions an arrest.
Right.
Now that entire email is, the response is no record information because one arrest was mentioned in it. I just don't understand how that would work.
Yeah, I think it's because of the work that Section 15A does. And 15A is about information. 15A says in the response to requests for information or records.
But it says of the person who was arrested or convicted.
Correct.
So it's not any information about that has nothing to do with an arrest or a conviction. It's only information about the person who was arrested or convicted. And then if you keep reading, it says with respect to the arrest, conviction, or related proceedings, which are the subject of the order. And the orders are only about, or at least in this case, the order is only about the arrest. It's not about the underlying incident. It's not about, broader conversations about whether this type of thing is or is not important that the mayor and the police chief might be having.
Right. We're on the same page, Justice. If the email hypothetical between the mayor and the police chief only discussed, to Justice Hoffman's point or question, about the underlying incident, then I think there is no implication of an expunged information that would be in danger of being disclosed in that instance. I think
you mentioned that the cat's out of the bag if there is a generic explanation for redaction.
Yes.
From the point of view, and we appreciate you being here to represent the municipal courts. From the point of view of the municipal clerk, if the clerk takes that precaution and provides some message that would convey that there is something out here, but you're not going to see it, and then a court eventually does an in-camera review, and the court either says this is in or it's out, the municipal clerk is no longer in peril of criminal prosecution. Am I correct?
Well, possibly, Justice. My concern is what would be said in the first instance before it got to litigation. If the clerk is somehow disclosing information, whether it's explicit or implicit through its explanation, that's where my concern is, that there is. And so if the court may take that position, and if it does, then I understand. But what I would ask then the court would do is to at least immunize clerks or municipal officials from the specter of being held a disorderly person for knowingly disclosing information that's expunged. See, I think a bright line test
why wouldn't guidance from this court as to how to handle as to what message to send with a redaction, hypothetically, be sufficient?
Because I think the court would have to grapple with Section 15A and the idea that 15A, the legislature is saying You don't state even a reason. You just say it doesn't exist. That's the response from the agency. And by the way, that's quite
So that
notable.
again just relies on the idea that any IA proceeding is a related proceeding to an arrest or conviction.
I don't think so. Again, we don't draw a line. We don't take a position on whether the IA proceeding is a related proceeding under the statute. We're focused on the fact that there is expunged information that's being requested. So where it says the arrest or conviction, so in either the report or the email hypothetical I was referring to, if either document reveals expunged information, meaning so-and-so had been convicted or arrested, and we now know that that was expunged, that's the problematic information that cannot be disclosed, and for which Section 15A says the response must be there is no record information. That's an extraordinary statement of the legislature to essentially say you must report a fiction. You must.
But it specifically says shall reply with respect to the arrest or the conviction. So if someone submits a request saying, was there an arrest? Was there a conviction? You're supposed to respond, no record information. It does not say that you have a 30-page report about many issues of public concern. There's one arrest referenced in it. Now the report no longer exists because you decided that you can't redact that one sentence.
That is one way to read it, but I guess I'm harmonizing Section 15A with Section 30. 30 says essentially
and it's about the existence of an arrest, conviction, or related legal proceeding. And you said you're not taking a position on whether the whole IA proceeding is automatically a related legal proceeding. So still, we're only talking about the existence of arrest or conviction, not some 30-page report that one sentence mentions that there was an arrest.
Right, Justice. But what we're talking about is what should the response be when the information is requested? And I think you have to read 15A with Section 15A with Section 30. And when you read the two together, it seems to me that the legislature was saying you are not to release the existence of expunged information. And that seems to make sense.
If the clerk doesn't, if the clerk says, here's the report with redactions and some generic language that does not specifically state that this called for the production of expunged information.
Right.
And that then goes forward into a court proceeding, which may or may not result in a court doing an in-camera review of the unredacted version.
Mm-hmm.
What peril is the municipal clerk then in?
Right. So I would have two questions, Justice. The first would be, what would the response be? And the court could, I guess, decide that it's permissible for the agency to not provide any explanation in that context.
Even if it's the generic response that we talked about earlier.
It could, but my fear is that it could still implicitly reveal the information that the legislature is trying to avoid.
But it's not. The general response that was discussed earlier was pursuant to law, these redactions have been made, period.
Right.
That is not explicitly revealing the existence of an arrest, conviction, or a related legal proceeding. It's not. And as Justice Patterson noted, if the requester does file a lawsuit and the case moves on to trial, it could be the case that there's sealing that's requested or in-camera review. So what, again, to Justice Patterson's questions, what is the peril here? I understand that, well, maybe the public or the requester will say, aha, this is redacted because this is an expunged arrest.
Right.
That's an assumption. That's an assumption that's being made. I'm not sure that's
right.
The reality looking at the statute.
Understood, Justice. I guess my concern was that it doesn't sound like an explanation to me. And
which the GRC requires and which is the ordinary course. And I get what you're saying in the sense that if that's an answer that hasn't previously appeared right. in situations where there's redaction, people who are familiar with the way this works may say, "Oh, this must be the redaction based on expungement."
That's exactly my concern.
Matter. But here again, my question is, if there were some guidance from the court mm-hmm. and the clerk followed that procedure, maybe a court agrees, maybe a court doesn't agree later, but it does seem to put the clerk in compliance with law.
Agreed. There needs to be a relief valve in a sense. So that would be my first question. What would the response be? The second question would be, are we lifting this heavy cloud off of the backs of clerks and the agencies, and so that they no longer need to be fearful of being deemed or designated a disorderly person by voluntarily disclosing the information that the legislature says ought not to be. So if those two concerns are
But
addressed
are
by
you
the court,
asking here for a immunization that the legislature hasn't given clerks in any generic sense?
well, I think at the very least, we would ask for there to be some sort of, holding that would give the clerks protection. I mean, Justice, what we're really getting at here, and I read the Attorney General's brief, and I thought it's an excellent brief, and I have the greatest respect for the office. But the three-step framework proposal sounds to me an awfully lot like something that would be maybe appropriate for legislation and not necessarily a judicial fix. And so this, I think, is the trouble we face with this particular case. It's why it's interesting. I would add just one or two things, if I may, and I really appreciate the court's indulgence. One is that when the court considers how to balance the fact that we have an expungement statute and the fact that we have a lot of law with respect to the common law, and how do we reconcile the two, I think the court should be mindful that Section 30 in the expungement statute, 32, I believe it is, does have a rule of construction. That rule essentially says that the chapters must be construed with the primary objective of providing relief to the reformed offender. That to me sounds like that the statute or the chapter as a whole has to be read liberally and broadly. That would, I think, counsel in favor of more precaution and withholding or redacting information than not. And then the second point I would make is that, and Justice Alvin, I believe, said this in the Farmer Mutual case, that when we have a collision between a statute and the common law has to give way. We know that the common law preceded the expungement statute, so the legislature essentially was stepping in when it passed the expungement statute and gave its imprimatur on what to do when it comes to expunged information. And so I would encourage the court to consider that guidance when it weighs what to do here. And ultimately, again, to be mindful of the fact that this case could have serious repercussions on municipal clerks.
Thank you.
Thank you.
Sam, I'm going to ask you to start with the question. This won't be a complete shock to you, the question of redactions.
Absolutely. Good morning, Your Honors. So as to the redactions, there's been a lot of questions this morning about the mechanics of how this would work. And I think one concern raised by both the municipal clerks and Jersey City is how the redactions would be explained. And I think something at a sufficient level of generality, such as subject to a judicial order, would be sufficient. That wouldn't necessarily reveal that the order is an expungement order. There could be other protective orders or other judicial orders at play that would require confidentiality. And that would discharge the responsibility to explain.
And that would be a reference to the judicial order of expungement, not to anything going on in this particular, doesn't assume there's already been some sort of adjudication.
That's right, it's referring to the expungement order.
Thank you.
And it's true that a common law requester might be dissatisfied with that, might continue with litigation. But I think as Justice Swinrafter pointed out, there's nothing unique to that problem. Common law requesters or OPRA requesters can, seek further information or litigate their rights, and there are standard procedures available. You can request to proceed under seal and then have a judge review in camera. So I don't think there's anything uniquely perplexing about that problem once you have litigation over whether information one party is claiming to be confidential gets to be released or not.
Do you have any second alternative suggestion in addition to subject to a judicial order as language that might accommodate all the conflicting interests here?
I think that's the best one. I mean, redacted in accordance of law, which was suggested earlier, I think is just one level more vague. And so I think the judicial order option provides a little more guidance. So that would be my best suggestion.
But we don't want to provide that guidance, right? If that guidance indicates that that order may be an expungement order, why would we want to provide that guidance?
I think it's just balancing giving the requester something more than just we permissibly redacted this, which I think is what in accordance with law is kind of getting at, without in any way telling them there is an expungement order at issue or even very likely leading to that inference. I think
because it could be any order
Any
regarding
order.
confidentiality, regarding attorney-client privilege, regarding anything.
Could be anything. Yeah, as Justice Pierre-Louis noted, I mean, people can speculate however they want. People could jump to those conclusions, but you wouldn't be
After this case,
violating.
they might know that it's it's an expungement now.
There would be
But
no
you're right. It's
violation
more,
of the
it could be any order. It could be any order.
And in theory, even if they were to speculate that there was some expungement, they would have no idea if it was an arrest or a conviction or exactly what was expunged because everything would be redacted.
That's right.
And if they said, hand over the expunged records, they're unlikely to have a positive result from that request.
That's right. And just to clarify there, I think that's a good segue to some of the textual arguments which Jersey City has put forth as to why an IA report is a record that can be expunged, which I think is clearly not the case under 15A. And I just want to pause for a moment to highlight the implications of Jersey City's argument. Were an individual seeking to learn how a law enforcement agency responded to officer misconduct serious enough to warrant criminal proceedings, Jersey City's submission is that where the officer has obtained an expungement, the law enforcement agency must respond, there is no record information. That would suggest there was no IA investigation, there was no response, there was no discipline at all. And that's extremely alarming from the Attorney General's perspective. It would severely undermine public trust in law enforcement and that there is an internal affairs process that is operating properly. So I think if this court were to accept Jersey City's invitation that the requirement under 15A to respond, there is no record information, applies to an IA report, it's extremely alarming. And I think that there's no indication in the expungement statute that that was the legislature's intent. And I want to walk through three potential arguments I thought Jersey City was raising for that result and explain why they're wrong. So first, Jersey City emphasizes the word information throughout the expungement statute. And it's true, the word information appears in the expungement statute, but I think in context, it's clear that where the expungement statute refers to information contained therein in an expunged record, it's referring to the fact that the expungement statute bars not only physically turning over an expunged record, so you can't physically turn over the expunged arrest report, nor could you tell someone, oh yes, Joe Smith was arrested on September 2nd. So that's the expunged information is the fact of the arrest. You can't reveal that, nor can you turn over the physical object. You can't turn over the arrest report. And I think when you see information contained therein in the expungement statute, that's what it's getting at. And I think there's several textual clues when you read all the provisions of the expungement statute together that get you there. So again, you see information contained therein in 15A in the second sentence. And again, it's saying the designated person in charge of expunged records must ensure that those records are not released, nor is the information contained therein released. Again, I think what they're saying is it's not that you just can't turn over the report, you also can't confirm the fact of the arrest that the report reveals. And I think the fact that this is the appropriate reading, you can see from if you look at section 30 and you look at section 27. So section 30, as this court has, numerous members of the court have pointed out this morning, only prohibits revealing the existence of an arrest, conviction, or related legal proceeding. There you don't, broadly see any information, however, related to these things. And then in
Let me
27.
stop you there,
Yes.
because if this were not a police officer and an IA record, and you were here on a case involving the scope of the expungement statute, and there was a description and a document of a fight that led to somebody's injury or a death, the records are expunged. Would the description in that document, whatever it may be, about the incident that gave rise to the arrest be within the scope of the expungement statute?
No. And that's because one does not have expunged descriptions of misconduct that occurred. One has expunged criminal records. One has expunged that one was arrested, the criminal record of that arrest, that one was convicted, the criminal record of that conviction.
So
Sorry, I want to make sure I understand. So there's an arrest report and it discloses that a fight took place. You're saying the fact that the fight took place is not expunged, but the fact that it's an arrest report is expunged?
So as to the types of documents that themselves get expunged under 15A, and you know which documents those are by looking to section 1, which defines the type of records that themselves get expunged. So Justice Wayner, in your example, an arrest report is a type of record that itself gets expunged. So that arrest report, it's like you can think of expungement as a physical thing, right? You take the record, you sequester it, you isolate it, you put a designated person in charge of it, and you say that this can't be referred to or used for any reason other than in the limited exceptions laid out in the expungement statute. So 15A requires those results as to the types of records listed in 1, and they will be specified in an actual expungement order. So those records actually get expunged. So section 1 says what types of records those can permissibly include. They'll be actually listed in an expungement order. And 15A says what happens to those actual records. Section 30 is what makes this case a little more complicated. So section 30 doesn't just discuss what actually happens to records that are listed in an expungement order. Section 30 talks about revealing the existence of an arrest, conviction, or related legal proceeding. So our main submission here is that an IA report is not a type of record under section 1 that can be listed in an expungement order and that can be required to be sequestered, kept in isolation, not used or referred to for any reason under section 15A.
So does that apply, what applies in this case to IA reports, would that apply to a document that is not among the documents specifically listed in the expungement statute, but in which part of an arrest report, let's say, and let's talk about the description of the incident and the arrest, is cut and paste into another category of document? I don't know what that is. I assume that happens. Does the AG's position on IA reports also apply to provide for the disclosure of any other type of document that doesn't meet that statutory enumeration of categories of documents in which, for whatever reason, an arrest report has been in part or in whole cut and pasted into that document?
So the answer is no, and I want to elaborate. So no, it is not the case that the causal origin of information in another document, just because it can be traced to a record that has been expunged, we don't think that's a reason that information somehow is categorically outside of the public view.
Would that be like a witness statement, for example, that might have exactly the same information that's contained in the arrest report, that's in the warrant, that's in the complaint, and then in the internal affairs record?
So if a statement by a witness, if this statement is actually part of a criminal file that got, I think it's possible that could be a record that actually gets expunged.
What if that statement was given to the internal affairs officers?
If that's a witness statement that's part of an internal affairs process, no, we don't think that. I mean, if it's talking about the arrest of an officer, that might get complicated under Section 30. But if it's just you interviewed a witness, just because it's about the misconduct that is also described in an arrest report that's expunged, that doesn't mean that information it has to be expunged.
Counselor, this is exactly what I struggled with too, because I feel like you've given a slightly different answer now than you did in your briefing on the hypo that I struggled with. This is the Officer Smith punching the patron hypo, and you say, if the report states, according to the arrest records, Officer Smith punched the patron. And your briefing says, well, you can leave in the exact quote, Officer Smith punched the patron, as long as you take out according to the arrest records. Now, if that exact quote came directly from the arrest record, then I feel like that's problematic, and I feel like that's what you just said. But in your briefing, you said, even if that express quote is lifted verbatim from the arrest report and goes into the IA report, it's okay, as long as you don't say it comes from the arrest report. I struggle with that because then there's no distinction between according to an independent investigation done by internal affairs and according to the arrest records. Because if you just take out according to the arrest records, you've still lifted verbatim from an expunged record and putting it into the IA report. So I have a hard time reconciling the answer you just gave, which happens to resonate with me, with what you had written in the brief.
Thank you, Justice Hoffman. So apologies if the brief is unclear on this point. We definitely did not mean to say that because information has some kind is causally derived from a criminal investigation, that it could not be, that if it were revealed, that would implicate Section 30 of the expungement statute. And I want to just explain why I don't think there's any textual basis for this sort of causal origin argument. Why it's inadministrable, I think, so it'd be very difficult for municipal clerks, and why it would lead.
So you're saying it would be inadministrable?
Inadministrable. It would be very difficult. So
The causal.
yes, because there you would need a municipal clerk to know how did the IA investigators learn of this information, and I don't know why they would have any reason to know of it. So in the hypo in the brief, it's very obvious, right? It's written what the causal origin is, but that might not be the case. And, you know, if factual findings were written into an IA report and they did happen to learn of those because, say, there was a conviction and that was all resolved before the IA investigation even got started, and the IA investigator, you know, reasonably took from a finding beyond a reasonable doubt of a jury that something occurred, that certain misconduct did occur. I don't think there's any reason from the expungement statute that factual conclusion, oh, the officer, you know, did use excessive, you know, did engage in this conduct which violates an IAP, an internal affairs policy and procedure prohibition on excessive force.
But bearing in mind that the municipal clerks face potential criminal liability, are you really saying to us that the municipal clerk is okay as long as the cut and paste from the arrest report is not attributed to the arrest report? Is that, maybe I'm hearing wrong, but is that what the AG would be saying to municipal courts is okay under the expungement statute, which we're supposed to be construing in the manner in which it's been previously discussed?
Yes, so I think we're sticking very strictly to the language of Section 30. And so we think under the language of Section 30, you cannot, with knowledge that a certain arrest, conviction, or related legal proceeding has been expunged, reveal the existence of that arrest, conviction, or related legal proceeding.
So would another way to think about this be, let's say there's a car accident and a municipal police department puts out a press release saying that there was this car accident, perhaps so that people can avoid the road or something like that. Then there's some sort of arrest or conviction or not, and that eventually gets expunged. The original press release that explained the fact of the car accident is not itself ever expunged or removed from the internet.
That's absolutely right. And you can look to this court's opinion in JD versus Kenny for just a discussion of the fact that expungement does not erase facts from the world that might have been public knowledge for 10 years before an expungement came into play.
But
So-
if it said that driver one was arrested following the accident for DWI or whatever, that would be redacted if that same request was made that covered the subject of that press release?
So I think in Justice Weiner After's example, it was a news agency. So, and if that news report all came out before the expungement, Section 30 wouldn't be implicated for a few reasons. One, you have an entity that isn't a law enforcement agency or criminal justice agency.
Mine was actually a press release put
Oh, I'm
out by
sorry.
the municipal police department, perhaps so that people would avoid the road, or some sort of alert on social media. You know, there has been an accident on X road,
Sorry.
avoid the area, something like that.
Yeah, so the analysis would go, you would think of the person at risk of liability, and you would ask, did that person have knowledge of the expungement? And then notwithstanding that knowledge, did they knowingly reveal the existence of an arrest, conviction, or related legal proceeding? And so I think as long as they have not done that, they're okay. And so if the press release was before the expungement, for example, you couldn't violate Section 30. If it was after, I do think someone with knowledge of the expungement would have to take care not to knowingly reveal the existence.
And the press release is in the police department's files. Is that an expunged document? Because it says in it that driver one was arrested on suspicion of DWI at the scene.
So I think, again, so whenever you're asking what actually got expunged, I think you're looking to Section 1, you're looking to Section 15A. It might be that some document is in the criminal investigatory file, which also exists elsewhere, for example, publicly online. And I think just because that entire file might get expunged in the sense that it's put in isolation, sequestered, doesn't mean that everywhere else that wants public information needs to be withdrawn from the public sphere.
And this is where we get back to the mechanical issue of if somebody makes a request just for that press release that Justice Weiner After is suggesting, and that's the only thing they're requesting, the municipal clerk might not have any way of recognizing that an expungement simultaneously exists in a different part of the municipality, because that's the police department. If they're looking for the municipal records of whoever puts out their press releases, they will look in that file, find the press release, determine that it's okay to send out, because there may not be any trigger point to say, let me look for an expungement at that point, right?
Yes, Justice Noriega. So I think the knowledge. Sorry.
And just to follow up, would then the individual have the ability to defend themselves based on what the request is? So if they say the request was solely for this information, it didn't relate to anything, as you say, is in that specific, 52-1 expungement zone. These are the items that were expunged. These are the file that's taken out and physically removed. This one wouldn't be included. They then have a built-in self-defense mechanism to that potential suit or accusation, because the request plus where that information is stored saves them from any knowledge of the expungement.
Yes, and I want to clarify the knowledge mens rea under Section 30, because this is a prohibition that has criminal consequences. It's a disorderly person's offense. And so we think Section 30 should be interpreted in line with principles of criminal interpretation, including the rule of lenity. You can also look in the criminal code 2C 2-2B2 is just the general definition of knowledge under the criminal code. And it instructs that a person acts knowingly with respect to the intended circumstances if he is aware that those circumstances exist or aware of a high probability of their existence.
It's the second part of that definition that I think probably is particularly troubling to the municipal clerks in this situation, because the argument could be made that that you can walk across the hall to the PD and find out there's an expungement order if you just did a little extra work.
So I think it wouldn't be enough that with some amount of effort, a clerk could have learned if the clerk did not know or did not know of a very high probability that there was an expungement. And to kind of highlight but I do think it's possible that the clerk hasn't literally seen an expungement order, but nonetheless, there might be a very high probability, the clerk might know there is a very high probability there is an expungement order. And to give an example of how that might work, certain types of expungement either happen automatically or there isn't discretion from a court to grant the expungement. So for example, when an individual completes a supervisory treatment program, so they complete PTI, 6 months after that, an expungement is entered.
So how does the municipal court clerk know that the person who was in the accident 4 years ago has successfully completed PTI?
That's why you just couldn't have the press release. The press release itself wouldn't be expunged, right? If the press release of the facts of the accident.
That's right, would not
An
get
accident
expunged.
occurred on X and Y street.
Yes, there's been a few hypos. I think one put the press release into the criminal file, and so that's getting a little complicated. But if just the press release referencing facts.
And referencing the arrest, if it's a press release, not in the criminal file?
Referencing the arrest after expungement would be a problem if the person who did the press release knew of the expungement. If that was done before the expungement, you can't have knowledge of the expungement, so there would be no Section 30 problem. Justice Patterson, I do agree that to the extent it's not reasonable that the clerk would, or not even reasonable. I mean, you have to show that subjectively they were aware of the order or aware of a very high probability of the existence of the order. I think that's the standard, and there may be circumstance where it's harder. I don't know. I mean, there might be some circumstances where it's hard to figure that out, but I think that is the standard, and I think it is a high standard.
But do you acknowledge the point that's being made by your fellow amicus in this case, that this is a significant complication for municipal clerks who are faced with these requests? But these the guidance is needed to try to clarify some of these issues.
I think guidance is definitely needed. I think, again, Section 30 is only going to kick in where there subjectively is knowledge of the expungement order, where there is a subjective, so the municipal clerk is subjectively aware of a very high probability of the expungement order. So you were saying maybe the clerk doesn't know if the supervisory treatment, if the PTI has been completed, that probably wouldn't satisfy, but say they do know. So they don't know the expungement order, but they know the supervisory treatment period has been completed and that a court would have no discretion not to enter expungement in that circumstance. And then they know they release an unredacted reference to that charge that might trigger liability. But I do think it's a very high standard and it is required knowledge by the clerk.
Thank you. Counsel.
I'm happy to address any of the other issues in the case, such as Section 19 or the common law, whether you can get these under the common law, but we would rest on our brief. Otherwise.
Thank you.
Thank you. May it please the court. There's a lot to do here because the court has a lot of practical questions and I want to get to those. I also want to get to the common law because that is the certified question before the court and there's been really no discussion of the common law and the role it plays here. But before I do those things and respond to some questions, I want to use my opening to give factual context because in the common law, factual context matters. And so the factual context of this case is this court's long line of decisions and directives by the Attorney General that recognize that transparency is very important to the public trusting the police. And the public often feels that police are given special treatment, that they cover up for each other, that the internal affairs unit doesn't hold their fellow officers accountable. And I've personally seen that every time we come to this court and obtain a landmark decision that gives us transparency, then we see agencies finding a way to evade that transparency. And so those things are all present in this case. Let's start with the initial conduct. Despite it the officer being charged with a Graves Act offense and engaging in conduct that I think you could fairly describe as domestic violence, he was shockingly allowed to enter into PTI. Now, we filed this case before there was expungement. I talked to a lot of criminal defense attorneys who all assured me they were shocked by that and can't fathom that any of the defendants they ever represented would get this sweetheart deal. Despite that offense, despite Jersey City Police Department being able to see the witness statements and those sort of things that really reveal intentional conduct, the IA unit concluded that it was merely negligent behavior, and this officer received only a 90-day suspension and is still on the force, despite his dangerous behavior that could have resulted in killing someone. As far as transparency, in early 2021, Jersey City published its annual major discipline report, which at the time did not have names attached to it, and gave pretty significant details to the public that the officer had consumed 6 to 8 beers, negligently discharged his firearm after a dispute, and was arrested and received PTI. But after this court upheld the Attorney General's major discipline report, and Jersey City had to amend its report and attach a name, suddenly those details are gone. And the new details simply, reveal a list of charges that he had and said that he negligently just discharged his firearm while at home, left out the dispute, left out the 6 to 8 beers, and left out the arrest and the PTI. After this court issued Rivera and gave access to internal affairs report, my client, having reported on this conduct from the major discipline report and having received the records elsewhere that really told us what the officer did, filed an IA request for the IA report. At the time, there was no expungement. And it's really difficult to fathom the Rivera factors ever weighing in favor of non-disclosure. But yet Jersey City denied access to the report and we had to sue for it. And then they fought the lawsuit despite us briefing why Rivera so clearly applied. And they even moved for sealing before there was an expungement order. And now, while we're very thankful that the Attorney General agrees with us on a key issue about whether the expungement statute reaches the internal affairs report, although we have some disagreements. Let's be clear that the Attorney General's proposed redaction in this case would, yes, give us information about what the officer did, yes, give us information about the internal affairs department's conclusions, but what it would shield by with the redactions would that it would shield that the officer receives special treatment from the prosecutor's office by getting PTI in this case in a Graves Act offense. And so we're disappointed by that. We're disappointed by the fact that the AG has not bothered to review the internal affairs report despite being the chief law enforcement officer, so they could weigh in on how the common law balancing test would come out. And we're even more bothered that the Attorney General recently promoted the assistant prosecutor who gave this special treatment to the cop to be acting county prosecutor.
Let's focus on the issues that are before the court.
Well, I think those are before the court because this is a common law balancing matter. So that's why transparency is important here. And I can talk about the role of the common law, but I think, we've been talking about this case in the context of there being an expungement. We filed this case, the client filed the request months and months and months before there was an expungement. If Jersey City had complied with the law as it was at the time, we wouldn't be here. We would have the report and we would know these facts and there would be no talk about liability because nothing was ever expunged. And so I think those are important things for us to note. Before I go into some of the practicalities and the questions the court has about those, as well as some statutory language, I do want to talk about the common law. I think that we think about the common law in Oprah. I think the court's decision in Rivera reflects what I'm about to say, but the common law right of access to public records is different than other forms of common law. And I think that since the enactment of Oprah, it's actually a statutory right. Is it an absolute statutory right to a record? No, it's a statutory right to a qualified right of access that's subject to balancing, but it's nonetheless a statutory right. And what I mean by that was when the legislature adopted Oprah, they adopted a policy whereby any document that is made or maintained by a public agency constitutes a government record. And so there's a presumption that it's subject to public access unless an exemption applies. And so in this case, the exemption that would apply would be 47-1A9, which recognizes any grant of confidentiality or exemption set forth in another statute or regulation. In this case, it would be a statute. But then Section 8 and Section 1 of Oprah both say that nothing in Oprah, there's no exemption that is intended to overcome the common law right of access. And so I think that's what makes the common law right of access different than any other area of common law. And I think that's reflected in old right to know law, old right to know law cases like Home News, where there were statutes and regulations at issue, but nonetheless there was common law disclosure. But it's certainly reflected in Rivera itself, because
Sorry, I want to make sure I understand. So generally the common law, if it is truly common law and it is not based on the Constitution, can be overridden by the legislature. They can say, you know, we actually want to pass a statute on this topic, and go ahead and pass a statute,
Yes.
correct?
Absolutely.
But you're saying that in this case, or I'm not sure if this is what you're saying, I think your adversaries were saying this is what you're saying, that in this case, the common law cannot be overridden by a statute?
Yes, that is what I'm saying, that the statute, as the court said in Rivera, the statute can weigh heavily in the court's analysis. It will consider it in the balancing
actual
test.
holding in Rivera was that information that's inaccessible under Oprah may still be accessible under the common law, correct?
Right, because the common law right that Section 8 and 1 of Oprah is referring to is a qualified right to the record, but you still have the right to go to the common law and have that
But the
balancing
legislature
occur.
specifically says X record shall never be disclosed. How could the court overrule that?
Because you have to harmonize it with Oprah, which does say that no exemption under Oprah, which is what the expungement statute is. It's only an expunged record would only be exempt from access under Oprah via Section 9, which would recognize the expungement statute. So
Sorry.
Oprah then says any exemption is still, you still have a common law right of access to it. And I think that's consistent with Rivera, because Rivera itself was the same path of access. The court said, if the court looked at I forget the exact statute, but it ends in 181, and it's the statute that requires agencies to adopt the IAPP, which has confidentiality provisions. And the court said there is a statute that exempts it under Oprah via Section 9, but nonetheless, this court might give, highly deferential to statutes and regulations, but it's not a categorical bar.
How does that work? How could this court, unless it is constitutionally required, under what authority can this court overrule the legislature when it passes a law that says X will not be disclosed?
Well, that's what happened in Rivera. There is a statute, the 181 statute, that says every agency must adopt and comply with the IAPP. The IAP has absolute strict confidentiality for internal affairs files, yet this
There was no statute in that case that said X shall not be disclosed.
Well, the court goes through 40A 14181, mandates that every agency adopt the IAPP. And also, you can go back as far as like Home News. Home News included statutes and regulations, and the court still granted access to it based on the common law balancing and the legislature's intent.
Back under the Right to Know Act, wasn't it?
Right. So this concept existed even then. And now I think the legislature, and if you look at the March 2000 hearing on Oprah that we've talked about in almost every case that we've been here, there was a lot of discussion about the role of the common law and how this court in Home News had granted access despite there being statutes and regulations, and that the legislature, lots of discussions about how they wanted to maintain that common law right.
And you're saying that under the common law, we could simply say that this expungement law is fine to the extent it doesn't, that we don't disagree with it, but there are parts of it that we disagree with, and therefore those need not be applied?
It's not, well, I would say a few things. One, it's not that, I think that in terms of the Attorney General's position, so we can put the dispute about redactions aside. In terms of the Attorney General's position, which was also our position about what the expungement statute covers, and it doesn't extend to internal affairs reports, and how this police department isn't the law enforcement arresting agency.
No, I understand there are areas of
Understood, but
agreement.
you were making a different argument. I
Yes, so
thought, which
now I'm
was
going to.
we shouldn't be talking about the expunged statute at all because the common law overrides a statute.
No, I'm not saying that you wouldn't talk about it at all. It's part of the balancing test, just like it was part of the balancing test in Rivera, and was part of the balancing test in Home News. And I think
How would that look? Justice Patterson asked, what would the balancing test would be the court saying we disagree with the legislature, even though the legislature has said this must never be turned over. We are going to decline to enforce that.
well, I think that it would look like that is a very important public policy that the legislature enacted in the circumstance. And so we're already in the world of internal affairs reports, which means you get very few of them. You get the ones that are already very compelling
But your
circumstances.
point could apply to any aspect of the expungement statute. Somebody could come forward and say, the public has an interest in this. This is a serious crime. And you're suggesting to us that we could simply say, that's a really important point. So
Well-
the expunged record should be available to the public in certain categories.
I don't necessarily think so. I think that there are also statutory hooks for what I'm saying. But again, I just want to get to the notion of this court already held not only as recently as Rivera, but way back at Home News and all those cases that the common law can trump a statute, and you take the consideration of the statute as a factor. But when the circumstances are very compelling, there is a public right to access.
I want to ask a different question, and then I'm going to ask you. My colleagues will ask questions, obviously, as well. But there was a reference in a conversation with Justice Noriega and one of your co-counsel here about the situation where a former criminal defendant who now has expunged records was in an encounter with a police officer, and the IA report talks about the arrest of that defendant and the circumstances leading to that arrest. What is your position with respect to whether the same principles you're asking us to apply to IA reports when it involves the conduct of a police officer actually involves the conduct of the defendant? And what is the statutory basis for distinguishing between the police officer and the defendant who was encountered by the police officer?
Well, I would say a couple of things. I think the statute treats police officers differently, and I'll say that, and I'll come back to that.
That being the expungement statute?
Yeah, I think that what Jersey City here, and I'll explain why I say this, is seeking special treatment for police officers that's favorable to secrecy, but the expungement statute actually gives special treatment to officers that favors more accountability and transparency. But before I go there, I'll say I represent people that file complaints against internal affairs against police officers. And so I think that there is a different interest there. And I think that obviously the interest in the public transparency would not in that case be the conduct of the person. And so the reasonable solution would be you would redact the name of the person and identifying information about the person who is subject to the arrest.
And where in the statute do we, because it's been raised in a couple of the briefs, where in the statute do we see the legislature wanting to treat police officers when they happen to be the person who was arrested and prosecuted versus non-police officers as to expungement of their record?
So I would say, one, this comes down to the notion that Jersey City was not the arresting agency here. So if this were a request to the state police, I think we'd be in a different circumstance. We'd have to make different arguments because the expungement statute would clearly apply. The expungement statute we don't think applies for all the reasons that we said in our prior briefing, and all the reasons that are set forth in case law like EA and MDZ and like dozens of unpublished opinions that have refused to extend the expungement statute to agencies other than the arresting and prosecuting and the criminal court.
Sorry, you're saying the expungement statute would not apply at all?
We don't think it applies at all because Jersey City is not serving in that role. So I don't think.
So that's a different argument than the AG, and that opposes any form of redaction.
Right. So we do disagree with the Attorney General. I unfortunately the court didn't allow a response to the amicus brief. So there's a lot more for me to do here at oral argument than I anticipated. But we agree with the Attorney General in the concept that the internal affairs report is not covered by the expungement statute. We disagree to the extent that the Attorney General argues that that they are bound by not releasing any documents in their internal affairs file if they would otherwise be expunged if the state police held them. And we also disagree with the redactions.
If we do not agree with you that the expungement statute is irrelevant in this case, and we consider the AG's concept of redaction, what is your position with respect to what should be said? Bearing in mind that I think across the board, council has indicated the need for guidance for the clerks who are responding to the requests. What should be said about the basis for the redaction?
Well, so that comes to a practical question. I've had a list of them that I wanted to go into. It's frustrating to me when agencies say something like it's too perplexing for them, so therefore we should have no transparency. It's not perplexing to me at all. I know.
My question is not whether we should have no transparency.
I know the court doesn't have access to this information except the rare case, but I've seen so many internal affairs reports. Per Rivera, there's already so many redactions to them. Rivera says that you should redact the names of witnesses, the names of the complainant, any medical information, any other sort of personal information is already redacted. So you get a report, it has a lot of redactions, and under the common law, there's this, reference to GRC guidance and Oprah. Those same rules don't exist under the common law necessarily. The GRC has zero jurisdiction under the common law.
Let me just ask you my question again. My question is not about other redactions that are pursuant to Rivera or the general condition of IA documents as they come to you post Rivera. My question is, if there is a redaction because there is expunged information that finds its way into an IA report, what should the format of the redaction be? What information should be supplied?
I think what you would get when you request a Rivera report, and this is what you do get. You get, here's the internal affairs report that was responsive to your request, and redactions have been made consistent with Rivera and for privacy purposes. And certainly if the court, even if no matter how the court gets there, but if the court believes that redacting the arrest, and in this case, concealing the fact that this officer received special treatment, is something that has to be redacted, that would be, privacy is a perfectly reasonable expectation without having to cite the expungement statute. So that's what I would expect to see. Especially in the world of common law, you don't get this list of exemptions. Like the response would say, this internal affairs report is exempt pursuant to Oprah. Pursuant to common law, here's the report. Redactions have been made consistent with Rivera and privacy.
What about the suggestion of the AG subject to a judicial order?
I think saying privacy is sufficient, subject to a judicial order, doesn't necessarily tell me expungement, though, because there are confidentiality orders. We're seeing an increasing uptick where agencies get a request and they don't, especially the prosecutors, they for whatever reason just go to the court, or the police officer will go to the court and get an order so that it can't be disclosed, or certain parts of it can't be disclosed. So it's not necessarily revealing, but I think privacy covers expungement if the court is going the route of requiring privacy. While we're on practicalities, though, I know the clerks always present this as a very difficult job, and I'm sure sometimes it is. What hasn't been discussed is that since Rivera was issued, the Attorney General issued Directive 2022-14, which I'll say for shorthand codifies Rivera, although I have real problems in ways that it evades transparency that Rivera provided. But it codifies Rivera in the sense that it says this court laid out factors of the types of misconduct that should be disclosed. So crime, like criminal conduct, so that'd be this case, domestic violence, bias, false reports, the sort of serious misconduct, and when it results in major discipline and those sort of things. The 2022-14, if you look at it, codifies that in the sense that it now says no balancing is required. Agencies have to disclose this. And in terms of the clerk's knowledge, let's just be real, the clerk has zero access to the internal
Before we get to the clerk's knowledge, what is the significance of your argument regarding that
But it's not difficult because they don't have to do balancing anymore.
You're arguing that certain IA reports are now required to be disclosed without any kind of elaborate balancing of 11 factors that Amiki on the other side were pointing to, that this being, an
Right.
exquisite test that requires balancing of 11 factors. You're saying since that, the AG has said, no, you actually just have to disclose A, B, and C.
Right. So it's actually a simple process, but as you'll see in this case, agencies, that guidance didn't exist, but it's hopefully helpful now, but we still see some agencies not following
And
it.
how does that relate to the expungement issue that we have?
So what I would say is that in terms of the clerk, practically speaking, the IAPP makes internal affairs files locked down. So the clerk doesn't, I know we think of the clerk being the all responsible person, and ultimately they're the person named in the statute, and they're the person supposed to be nudging the departments to comply. But the clerk doesn't have this huge office of every file in the agency, and they have no access to the internal affairs file. So what generally happens is that the request comes in, the clerk sends it to the police department. The police department is often the one responding to the request, or it's going through counsel. So the police department would be the entity that has the expungement order. In a case like this, though, I think Justice Noriega, your point is on point. Your questions were on point, that expungement is contemplated with the criminal justice agencies that were involved in the arrest, that were involved in the prosecution, and the court that prosecuted the criminal or handled the criminal proceedings. The expungement order wasn't served on JCPD because even though they're just an employer and they handled an administrative function.
Once you have a state agency, a government body in this case, that does receive the expungement order, aren't they obligated to then act on that and take precautions to prevent expungible information to be released?
Well, I think this is what I come back to when I say treatment. The only statutory hook that Jersey City really has here is because they happen to be an employer that is a law enforcement agency. But the same 15 doesn't apply to the disciplinary review board, or doesn't apply to the real estate commission, or it doesn't apply to any of the medical boards or any of these other licensing agencies that will discipline someone based on their misconduct that resulted in criminal charges. It doesn't apply to them. So you'd have to see that the legislature intended to single out police officers and give them extra secrecy that I wouldn't get as a lawyer, or that a doctor wouldn't get. And the opposite is true when you look at the statute, in particular, section 5227, it singles out police officers there and says, although everybody else can answer, I don't have a criminal conviction or arrest if I have an expungement, police officers can't when they're applying for law enforcement
That's a different issue. We have an issue here, and that is that we have an agency that has the expungement order. So if what you're suggesting is that we simply tell agencies that are served with expungement orders, in this case, the JCPD, that you're really not what the focus would be. So just don't worry about the expungement order. I think we have to hear that from the legislature. I don't know how we could possibly say that an agency that is within the statute that gets the expungement order could simply say, I don't think we're in the bullseye of what was being talked about here. All we are is an employer.
Well, I think that there's statutory hooks. So 27 also starts with the language, unless otherwise provided by law. And it ends with the statement that I was starting to read, which is that law enforcement, anybody applying for law enforcement corrections employment must disclose it, and such information shall continue to provide a disability as otherwise provided by law. And I think a disability in the minds of an officer would be transparency, and unless otherwise provided by law is the common law. And there is a common law right in a situation like this. And the effect of the court's decision, if it allows the arrest here, is that we know a lot of facts in this case already, and we think we should be put back in the position that we were when we requested the case, or when we requested the record, or when we filed the case. But we know a lot of facts, and so sometimes that's beneficial because it helps us see look, this played out exactly like we all fear it plays out. The cop got special treatment, those sort of things.
But if
we
the court
took
is not, and I don't, obviously can't speak for anyone here, but if the court is not willing to view the expungement statute as something we could set aside because we consider Jersey City's PD to be somehow outside of it in this situation, and there is a practical solution to be devised, what are your suggestions?
Obviously, the Attorney General's position would be a win, that we definitely should learn about this officer's conduct. We should definitely, and the fact that parts of police reports might have been copied and those sort of things. We should receive that conduct. We should receive that information. And so a redaction to, but I want to make it clear what a redaction to the arrest and PTI does is harmful to, because what would the public see? Let's take ourselves out of this world where we know so many facts because these records that are now expunged were filed on a public docket, which they're still there, by the way. And so that's Exhibit C to the complaint. So that's what my clients reported articles on and the other press says. Let's take ourselves out of
materials in the unrelated.
Right, Brady and Giglio. So let's remove that stuff from our knowledge. What we would instead say is, let's get this internal affairs report. It's going to show all this conduct by the officer, that was dangerous and egregious with the firearm. And then it's, if references to the arrest are made, maybe the state police showed up, no reference to the arrest, or maybe no reference to the state police showing up. And then the officer gets a 90-day suspension. That disclosure of that report leaves out important information and I think feeds into the lack of trust in police. Because if I read that report, I'd say, how on earth did the state police come and then not arrest this person? Or why didn't this police department not call the state police to prosecute this officer for doing that? And so I think GD Kenny versus Kenny is helpful also in the sense that the court has already looked at 5230 and gave it a common sense meaning. And what I mean by that is the court held that obviously my client and the general public can talk about this, right? But then it said, although it used this language in particular, although those employed in certain statutorily named government agencies that have custody of expunged records are clearly bound by 5230, a literal and overbroad reading of that statute would violate free speech rights. And you can't imagine that the legislature intended to punish via the criminal code people who want to speak truthfully about this information. And so I'm thinking about this case in terms of the public interest, and that's where we are with the common law. My client published a commentary today about how this case is extra important right now because the mayor of Jersey City is running for governor. And so 5230 serves to chill speech. And so what I'm thinking is if the court has an overly broad expansion of 5230 so that anybody who works for the government who happens to know that something has been expunged can't talk about it, but everybody else can, that could mean that like Steve Sweeney, the candidate who doesn't work for government at all, could talk about this and criticize Mayor Fulop for his quest for secrecy. But Mayor Baraka, who works for government, couldn't. And so this stifles the public debate. But we do think that there's statutory hooks in terms of this authorized by law language, and the court used that language in Reed, the expungement of DH, where it was dealing with the interactions of the expungement statute and the forfeiture of employment statute. And it said there that even though the expungement statute said that no collateral consequences of an expunged offense should occur, it looked at this section 27 and said, well, it does refer to unless otherwise provided by law. And when we look at the purpose of the forfeiture statute and the purpose of the expungement statute, and we conclude that the legislature couldn't have meant that you could expunge and therefore also expunge your forfeiture of employment.
Any other questions? Anything you'd like to add?
Well, if I could just address the concern that, because Justice Hoffman, you expressed it as being concerned about the IA process itself and how material would end up in an IA report. I think it's important to think about the context of what happens, which the Attorney General explains in the brief, when there's criminal conduct. So I will say most of the time in criminal conduct, the officers no longer going to be on the force. But in this case, they are allowed to be. But the incident happens, and then IA does nothing. They let the criminal proceeding, the investigators, the people on site, the arresting officers, the prosecutor gather information and handle the criminal process. And then because it makes sense and because of the passage of time and all of the reasons, largely they will often rely upon a lot of the police reports and evidence. And if they didn't, the reality is that you'd have to have the internal affairs unit arrive to the scene and check out the shell casings to see if they were there and interview the witnesses at that point in time to gather the best evidence for their own internal affairs investigation. And so instead they do rely upon, especially when it comes to like anything forensic, upon the criminal investigation. They also do try to reach back out to witnesses, but by the time that they might, I mean, in this case, it was a few months, but in another case, it could be a year or 2 years before the criminal process is done. And by that time, the witnesses might not have the best memory. In this particular case, it's a family domestic dispute. And so this officer's already received PTI, and maybe they don't want their breadwinner to lose his job, or so maybe they weren't cooperative. Or what I encounter so much is people just don't trust the internal affairs process, and they don't want to deal with IA, and so they don't respond to the calls from the IA unit. And so I think that those are practical reasons why police reports and evidence from the criminal proceeding do appear in the IA, but that shouldn't be allowed to require redaction of the facts of what happened just because it was copied from a police report. Because otherwise, I mean, Rivera means very little if you can't get the information in the very, very worst cases. So we would get information by police officers who maybe received major discipline for doing something much less, but then we'd have no transparency in the most egregious conduct. I don't think the legislature intended that. Every evidence in the statutory language is that they intended actually police officers to continue to have disabilities for their convicted or their expunged convictions, and to not be singled out. And again, the only statutory hook for why Jersey City as an employer would have the expungement statute extend to them is solely because they're a law enforcement agency. But if they were the real estate agent commission, that argument wouldn't exist.
But Counselor, the one distinction though, wouldn't it be that the real estate commission that is reviewing this, they wouldn't be relying expressly upon criminal files, right?
They might be, because there's a bunch of different licensing agencies that were committing crimes could be cause you to lose your license, especially if it touches upon trust or financial obligations and all sorts of things.
And they too can wait for a criminal proceeding to conclude and then get the criminal record.
And they do get the records, which is why often there's these cases that are about like, hey, you need to expunge your file, and the courts have all said no. And look at this. Look, we're lawyers, right? So the effect of the court's decision would be, if it goes the route of applying the expungement statute to the officer, would be that if I engaged in the same conduct or engaged in conduct that, I got PTI because I did something like stole money, the court would the disciplinary review board would discipline me for it. And that would be public, and it would be a published opinion. And even if it was my first offense and I got PTI and I completed it and I got an expungement, the court isn't, the judiciary isn't obligated to go through all of its files every time there's an expungement and then delete the DRB decisions. The facts are the facts. And in this case, the facts were all public. The cat is out of the bag. The facts were all public when we filed the request and when we filed the lawsuit. And now, I think some people think that maybe the request was denied in hopes that the expungement would come through and so it could never be disclosed, but it should have been disclosed under Rivera. And it can't be that all the counsel table at this table would have our discipline revealed, but two state troopers in the back who are here providing us security could keep theirs a secret. And that is the only hook, is the fact that it refers to their employer happens to be a law enforcement agency.
Thank you, Counsel. Nova.
Thank you, Your Honors. May it please the court. I'm here on behalf of the Office of the Public Defender. Obviously, we're extremely supportive of the expungement process. We support the way that an expungement allows a person to take their criminal history, and when they are applying for jobs, for housing, for licenses, do that knowing that when a background check is run on them, usually through the state police, that will come up as no record information. There's no criminal history on you, or at least there's no criminal history of that's been expunged. But we also know that expungements have limits. Expungements do not erase the underlying facts. And when those facts, and I believe, as I'll explain, including the fact of the arrest or the conviction, are contained in other records that are not things that normally come up in a criminal background check, but may be accessible in other ways, that is not related to or collateral to the expunged conviction. And as applied here to the public records request for an internal affairs file, certainly the facts, I think, and I agree with the Attorney General that certainly the facts in the internal affairs file are subject to disclosure. And I believe, as I'll explain, that also the references to the arrest or conviction, if they're contained in the internal affairs record, the document, are subject to disclosure. Our office believes that's important, both as a matter of transparency over police misconduct, which is an issue that we're interested in, and also specifically as a furtherance of our fact finding in terms of exculpatory evidence and impeachment evidence in criminal cases where we're representing people.
So do you part company with the Attorney General?
I do, yes, Your Honor. I think the Attorney General's kind of compromise position is, I think Ms. Griffin called it a win. I think it would be a partial win, but I do part ways with the Attorney General. We don't believe that the redaction of the mention of the arrest or the conviction is necessary, and we don't think it's helpful. And I do want to hear.
Just curious, I'm trying to understand too the mechanics. If the IA report just simply attaches an arrest report or attaches the affidavit to the arrest report and says, see arrest report affidavit. Clearly, the expungement statute would not make that accessible. But are you saying that because it's attached to an IA report, that exact same document should be accessible?
Right. So that's actually one of the concerns that I'm worried about, that after this opinion, the police departments will say, oh, if we just recite what's in the police report in our IA file, the facts are going to get disclosed. We're just say, see arrest report. I think you would probably wind up with litigation over whether that particular arrest record is discoverable. And I think a rule that says that the facts of the case and the facts of the arrest, if they're in the IA record, are discoverable no matter what, whether they're in an arrest record or not, will kind of avoid the concern that you just laid out, because there's no reason to just say see arrest report if we know the facts are going to come out anyway.
Simpler, but how would it be compatible with the
expungement statute? Exactly. So let me walk through a few provisions of the expungement statute, which also explain how these things work in practice, how we see them at the Office of the Public Defender work in practice, and explain why I don't think either 15A or 30 preclude the IA department of a police, the IA unit of a police department from disclosing a record that says Officer Jones was arrested, even if that arrest has been expunged. I want to start with a provision that actually hasn't been mentioned yet today, believe it or not. It's section 2C52-10.1C. So 10.1 is about how an expungement petition gets filed. It gets served on the state police, the Attorney General, and the county prosecutor's offices, and then it gets granted. And C explains what happens when the expungement order gets granted. And it says that the order is transmitted to the law enforcement and criminal justice agencies, which at the time of the hearing on the petition possess any records specified in the order. And so the order is going to specify what we're looking at and which agencies have those orders. The order in this case, I don't have it in front of me, but my strong recollection is that it does not say this is going to the Jersey City Police Department, because the Jersey City Police Department did not conduct the underlying investigation. It went to the state police, the Sussex County Prosecutor's Office. So 10.1C cross-references section 15.
Before you leave that,
Yeah.
is that of no significance in terms of the public defender's position here, that the order ended up in the custody of the Jersey City Police Department? Because it's not required, it's not in the expungement order. Are we simply to pretend it never happened?
Well, we don't pretend that it never happened, but the fact that the court didn't send it to the Jersey City Police Department, and I actually want to talk about the more difficult case where the police department is the prosecuting agency and the disciplining agency, which is what happened in the law division case Zamach that hasn't been discussed today. That would actually be a more difficult case. But in this case, because the court didn't send it to the Jersey City Police Department, I think that fact has significance, because everything they're talking about has to do with judicial obligations.
So if something is, so if a court issues an order in which it doesn't know or doesn't omits an agency that should be the subject of an expungement order, and that agency gets the order from maybe somebody recognizes that we ought to send this to this prosecutor's office too. I know they were involved. Is it PD's position that as a matter of interpreting the expungement statute, it doesn't matter? We can just pretend that agency didn't get it because it wasn't in the court order?
In those cases, my understanding is that we would go back to the court and ask the court to amend the expungement order to include that particular agency.
But let's just assume that for whatever reason, an agency got the order. Are you really suggesting, for all of the important considerations that underlie expungements, that an agency that gets an order can simply say, I'm not on this list. I'm not going to worry my documents people with this. It's going in the drawer.
Yeah, so I still think.
Do you see what I'm saying?
I understand. So,
this is an unusual case, but the ramifications of this case could impact the people who your client represents.
Absolutely. So I think that if we look to section 15, which is where I was going to go next, that will help elucidate the answer to your Honor's question, because there might be agencies where they really believe that their absence on the order was a mistake. I will say that I believe in our office's experience, my understanding is that those agencies usually tell us, if we're not listed in the order, go to the court and get an amendment. But the agency would still, I think, have a way to be faithful to the expungement order without overruling our position in this case, if we look at section 15 and then at section 30, because 15 then says that you're going to remove the files from the law enforcement and criminal justice agencies, which at the time of the hearing on the position possess the records. That's the records that were ordered expunged that are referred to in 10.1C. And then in a section that has been discussed a lot today, I think it's the third sentence, in response to court requests for information or records of the person who was arrested or convicted, you respond that there's no record information. So that is referencing a request to the law enforcement agency. Hey, law enforcement agency, was John Smith arrested or convicted? The answer to that question is no, or no record information. We have no record information of John Smith being arrested or convicted. That's not the request that was made in this case. The request that was made in this case was the Jersey City Police Lieutenant at issue arrested or convicted? It was he subject to discipline? The answer to that is yes. So there's a record containing that information.
So does the expungement statute, is its applicability contingent on the language of the request that is asking for records that are expunged? And as a general proposition, and here again, there's obviously enormous variation in how people ask for records. Is it really the PD's position that if that particular language, which may be the most technically true to the statute language, and I'm sure in requests that are made by the council in this room would be very technically correct, are we really going to say that if it's not asked for in that particular direct way, don't worry about it?
Yeah, I'm not talking about magic words. I'm talking about the substance of the request. Is the substance of the request about the person being arrested or convicted? Is there an arrest report? Is there a record of conviction? Are there records related to the investigation that led to the arrest or the conviction or the prosecution? That's the substance of the request.
And
The
is it a second part to that, that it also must be, the request must be directed to an agency that was ordered, right, by a court to expunge their records in particular?
Right.
So, and does that then mean that anybody who by happenstance that happens to be in government that received that order is not obliged under that order to then execute that request?
In fact, we know that the answer to your question is yes, because of the cases. The EA case that says when the records go to the licensing board, by the way, EA, that's an appellate division case, says that that person went to the licensing board, I think it was the real estate commission, and said, I want you to remove my expunged records from your file because you're making them public. I got an arrest, I got it expunged.
Wasn't part of that, tell me if I'm wrong, wasn't part of that because the licensing board is not a criminal justice agency?
Right. So I think the issue is that reading, that's why you have to read 10.1, we're sending this order to the criminal justice agencies that have the records, and 15, ordering criminal justice agencies to do the sealing, the isolating and extracting and expunging, have to be kind of read together so that if you get the records as a law enforcement agency, but you didn't get them as we did the arrest, prosecution, and conviction, but you have them instead in an IA file that is not about an arrest, prosecution,
leave the part that, because I'm really, obviously with great respect to you and your client, if you leave us aside the part about IA, you seem to be taking the position that if a law enforcement agency gets an expungement order other than being named in the order, and it's a law enforcement agency, and for whatever reason it gets to the agency, it can look at that order and say, I'm not worried about this. And I know you're saying, IA is special, but there may be cases that don't involve IA in which that would, and I don't see it in the statute.
If it's related, I apologize. If it's related to the investigation and prosecution of the crime, and actually, if you look at 10, Section 10 has kind of been subsumed by Section 10.1 because the notice now goes only to the county prosecutor, who's kind of the person responsible for doing all of the responding. But previously, when you filed an expungement petition, when you did it by paper instead of doing it electronically now, you had to serve the chief of police or other executive head, I'm in 10A, of the police department of the municipality where the offense was committed, and the chief law enforcement officer of any other law enforcement agency of the state which participated in the arrest of the individual.
Okay, so right? Is it the PD's position that if you're not on that list, if you're not in that category, and you somehow somebody gets you, whether it's a defendant who's concerned that you have the records that are expunged, whatever it may be, somebody gets you that order, you can ignore it.
Ignore is a strong term, but I think you're not
I'm
bound.
Saying it's pejorative. You're saying you're not bound by it.
When you
therefore, if you get a request or somebody just wants to disseminate information that's in the department or the agency, they can just say, not on that order, not worried about it.
Well, we're talking about requests, and there may be other confidentiality issues at play. When we're talking about the expungement statute, I think the answer is yes. And to go back a little bit to a hypothetical that Justice Noriega gave to Mr. Jacobson, it was a long time ago, so hopefully I get it mostly correct. But my understanding was the hypothetical was the IA report is about an officer's misconduct against somebody. That person was arrested. Maybe they were prosecuted. Maybe the case was dismissed. Whatever happened, they got an expungement. But the IA report might say, Officer Jones allegedly beat up Bob Smith while arresting him for X, right? and Mr. Smith filed an IA complaint against Officer Jones and whatever. I think that probably the person's name would be redacted in a Rivera request because the names of complainants and witnesses are often redacted. But I don't think, even if the police department has the expungement record for the person who got beat up, I do not believe the police department has to then redact the arrest out of that IA file. And I think that would make the municipal clerk's job extremely hard to be able to say, or even if it's the person in the IA department, really hard to say, okay, now I got this Rivera request. Now I got to look at every single expungement that we might have ever gotten anywhere, whether it came from the court, whether it came from a person. Was this person getting an expungement? Do we have to redact that word arrest? What do we say when we redact that word arrest? This is a significantly more difficult process than it is to say, if you have the records in connection with a prosecution, an arrest, an investigation, you can even look at those. Justice Hoffman was going through the apprehension and all that stuff, those terms from 1A. If you don't have the records in connection with that process, that's not subject to the expungement statute. That's the way the courts interpreted it in EA with the licensing boards. That's the way that
Not entirely though, because
it's not a law enforcement
not a law
agency.
enforcement agency.
Sure,
There's a huge distinction there between a law enforcement agency and the real estate commission.
That's right. So then you can look at the cases of mock. I know it's a law division case and it's a little older, but that is maybe the more difficult case. That was the Secaucus Police Department that arrested its own officer and disciplined him. And then he got an expungement and he says, I want my records removed from the disciplinary file as well. And Judge Oliveri says, no, we have the records that were done in connection with the arrest and prosecution. Those are expunged under the expungement statute. We have the other records that were compiled in connection with the disciplinary action. That's not subject to the expungement statute. That distinction, I think, is really important. Let me just highlight a couple of practical concerns as well.
Please wrap up.
Yes, I understand. One in
We've
particular.
passed 5 minutes.
Let me just explain. Let me just highlight one thing that I think would be really odd in this case. The Jersey City's argument, and I think the Attorney General's argument as well, really hinges on this. The Jersey City Police Department is a criminal justice agency, right? And they have the records as a law enforcement agency. Imagine instead this is a coach with the Jersey City Department of Recreation, a basketball coach who works with kids, who does the same thing. And there's a common law request for the disciplinary records of that. We found that coach is still working for the Jersey City Department of Recreation. What's going on? This is a dangerous person. We don't want them working with kids. We want to see the disciplinary records and understand what happens. They would have they might have arguments under the common law that shouldn't be disclosed, but they would have no argument about this concrete wall that the trial judge used in this case to say that record should not be disclosed. That's a real oddity, I think, in this case. That's just because it's a law enforcement agency.
But it's in the statute.
Well, that's why I kind of went through the statute and explained why I think the statute supports our reading. And I think there's a practical concern that the person who's at the police department shouldn't be treated differently than the coach from the Department of Recreation. That reinforces our reading of the statute.
Thank you. Mr. Jacobson, rebuttal.
Thank you, Your Honors. Just want to try to go through very quickly and address a few points. As far as 10.1C is concerned, the operative language is at the time of the hearing possessed the records, and Jersey City very clearly was in possession of the records at issue here at the time of the expungement hearing. So I don't believe that's an issue, and that language was inserted in place of anything having to do with notice whatsoever, backed by a 2019 amendment that the legislature made to the expungement statute. As far as 15C, the language is very broad in that it covers all officers, departments, and agencies, obviously meaning law enforcement agencies, criminal justice agencies, and so forth. EA, I believe Your Honors are absolutely correct. The fact that it was a licensing board, not one of the named agencies, takes EA and a number of the cases having to do with licensing boards completely out of the conversation here. I'd also like to just say that largely the respondent's argument was a policy argument. I believe that to the extent that they're looking for public policy changes, they're in the wrong building in Trenton. They should be lobbying the legislature for those changes. Particularly troubling was the notion that the common law somehow trumps the legislature's will. I think we can quickly look to Farmers Mutual 215 NJ 522 for the proposition that that's not the case. Nor does the city believe that Oprah somehow gives a statutory claim that the common law somehow prevails over some other statute. Oprah simply allows for a parallel common law right of access balancing test to the exceptions that Oprah creates. And Oprah creates plenty of exceptions that aren't covered by any other statute. The expungement statute has no such language. Therefore, the common law certainly cannot override it. And finally, I would like to say that the GD case, the same section of the GD case that adversaries quoted actually says straightforward that the 5230 does apply clearly to named government agencies, which law enforcement agencies and criminal justice agencies include. So we believe that actually supports our point. And I have nothing further. Thank you, Your Honors.
Thank you. And we will take the matter under advisement. I want to thank all counsel for the excellent arguments today.